Good evening. My name is Lee Gil Cohen, and I am the National Director of Personal Injury Litigation at Cantor and Pintaluga. Welcome to the Cantor and Pintaluga courtroom, and thank you for joining us for the live stream of the 2026 Cantor and Pintaluga Summer Associate Mock Trial. Tonight marks the culmination of a summer defined by learning, collaboration, and professional growth. Over the past several weeks, our summer associates have worked alongside experienced attorneys, gaining firsthand insight into the practice of law and the responsibility that comes with advocating for others. Now the classroom gives way to the courtroom. The mock trial challenges each participant to think strategically, communicate persuasively, and perform under the same pressures that define real litigation. This will all take place in a fully equipped courtroom and with an actual retired trial judge. Every opening statement, witness examination, objection, and closing argument reflects not only legal knowledge, but preparation, professionalism, and confidence. At Cantor and Pintaluga, we believe exceptional advocates are built through experience. Tonight is an opportunity for these future attorneys to demonstrate the skills they've developed throughout the summer and to take another step in their professional journey. To our summer associates, we wish you the very best. To our guests, thank you for joining us. We invite you all to enjoy the 2026 Cantor and Pintaluga Summer Associate Mock Trial. Let the trial begin.
All rise. The Superior Court of Hanover County is now in session. The Honorable Ilona M. Holmes presiding. Please silence all cell phones or they will be confiscated. And please remain quiet.
Thank you. Ladies and gentlemen, you all may be seated.
Okay. I'd like to introduce the Honorable Ilona Holmes. Judge Holmes received her bachelor's in political science from Florida Atlantic University. She received her law degree from Texas Southern University's Thurgood Marshall School of Law. She was admitted to the bar in 1982, and she served as an assistant state attorney in Miami-Dade County. She then served as an assistant U.S. attorney for the Southern District of Florida, and then she was appointed to the bench, to the Broward County bench in 1995, which is actually where I met her, a long time ago. She was appointed to the Circuit Court bench in 1998. She did some civil trials there, but her real passion were the criminal trials. She was a no-nonsense, tough judge. She always held the attorneys who appeared before her to the highest standards. She also allegedly received the most death threats of any judge in Broward County. She's been retired since the end of 2018. Now she honors us by presiding over our annual Summer Associate Mock Trial. Thank you very much, Your Honor.
Thank you, Mr. Cohen. All right, this is the case of Leery versus Witter Development, LLC. And counsel, I need you to note your appearances on the record so that the jury will know who's talking and why you're talking. So we'll begin with the plaintiff. Who's representing the Leery administrator, the state of Jamie Leery?
Good evening, Your Honor. My name is Derline Desjardins, and along with my co-counsels,
Francesca, Baleanu,
Jonathan Frechter.
we have the privilege of representing the plaintiff, Riley Leery, individually and as the administrator of Jamie Leery's estate.
Is Mr. Leery present in court?
Yes, Your Honor.
Good evening, Mr. Leery. Thank you. You all may be seated. And on behalf of the defense, Witter Development, LLC.
Yes, good afternoon, Your Honor. My name is Kalil. Alongside me, my co-counsel,
Briana, Garcon.
and we represent Witter Development in this matter. Defendant.
And do I have the representative from Witter?
Yes, she is Logan Witter.
Good afternoon.
Good afternoon.
All right, counsel, before we begin the trial, the jury has been seated. You all may be seated just briefly, because I'd like you to stand when you talk to me. Are there any motions in limine or anything that we've not covered prior to jury selection? All right,
Yes, Your Honor, we do have two motion in limines, but prior to our motions, we do have a few housekeeping matters requiring Your Honor's attention.
absolutely, you may proceed.
Would Your Honor like a brief recitation of the facts?
No, I've read the complaint, I've read the depots, I've read your stipulations, and we're gonna talk about those also. So I'm familiar with the case.
We also have a clean copy of the record along with a notice of appearance. We also have courtesy copies of our notice of appearance for the jury. May my co-counsels approach?
You may approach. The counsel, in the future, it would be great if you just pass these things to my office well before, not the day of.
Yes, Your Honor.
All right. All right. Tell me what you got in mind.
Yes, Your Honor, may we please have the proper pronunciation of your last name?
Holmes, Holmes.
Prior to stipulation 5, this case has been bifurcated into a liabilities and damages phase. For purposes of today's trial, we will only be trying the liabilities portion.
Understood.
May we assume that all witnesses have been previously sworn in?
I'll swear them when they come in, because I don't know who's doing the swearing around here.
Yes, Your Honor. This court operates under the Federal Rules of Evidence and Federal Rules of Civil Procedure. Your Honor, may both parties move freely throughout the well of the courtroom except for approaching the bench, the witness stand.
Yeah, and get permission before you approach the bench, witnesses, and they don't get too close to my jurors.
Yes, Your Honor. And would Your Honor like that we ask each time?
Yeah, say may it please the court, but if the witness is testifying and you've already gotten permission, you may approach
Yes, Your Honor.
without continuing to ask.
May all evidentiary arguments typically held outside of the presence of the jury be made wherever counsel is standing?
Well, sometimes I don't need to do it outside. I know the federal rules of evidence like I know my last name.
Yes, Your Honor.
I'll make that decision on an objection by objection basis.
Your Honor, we would like to use some exhibits during opening statements and also would like to pre-admit some exhibits that both parties have already stipulated to.
Well, since they've been stipulated to, does the defense have any objection to the plaintiff showing certain exhibits during the course of their opening statement? But keep in mind, your opening statement is just that. It's a roadmap for the jurors, and I'm going to remind them of that, and that what the lawyers say is not evidence. So I'll remind them, but if it's stipulated to in evidence, any objection to the plaintiff, and you will get the same luxury of showing whatever exhibits you want during your opening statement.
Yes, Your Honor, we did stipulate, and in my presentation as well, I do have some exhibits that will be shown to the jury.
Modern technology, we moved into the future here. All right.
So would Your Honor prefer that we move to admit them now and place them on the clerk?
Whatever it's easy for you, because I want to do this seamlessly, so I don't keep these jurors just sitting around waiting for technology to pull up stuff, so have them ready.
Yes, Your Honor.
Your Honor, may I approach?
You may. And for the record, has the defense seen what's just been handed to me? These the exhibits?
Yes.
Come on up and approach. I want you to see what I'm seeing and what the jury is going to see.
Thank you, Your Honor.
These are the proposed, these are the exhibits that the plaintiffs want to show. And don't get them out of order now. Got them in a nice order.
Exhibit 1 is plaintiff's.
And counsel, you may approach, you need to see what they're doing up here, make sure I'm not sending them any notes and helping out anybody.
So that's
What is it?
Exhibit 5 was
P8?
the items.
Yes, Your Honor, these are.
Yes, Your Honor.
And please make sure that they're in the same order that they were handed out.
Your Honor, where would you like us to place the exhibits once they've been entered into evidence?
Place them up here and I'll hold on to them. My clerk is doing other things this afternoon.
Sure.
order.
Those good, Your Honor.
You need these, or these were from the court?
Those are for the court, so
Thank
you
you.
can have a minute.
And with that, Your Honor, we are ready for the two motions that we have.
Also, before you begin, there are certain stipulations such as the evidence. I have a two and a half pages of stipulations. Did you all agree there are 20?
Yes.
Because I'll explain to the members of the jury that a stipulation is just an agreement, and nobody has to testify to the evidence that you intend to introduce because of the stipulation or agreement of the parties.
Yes, Your Honor.
I like to give a lot of curatives, so the jury is not left in the dark as to what's happening. Right? Any objections?
No
Objections.
All right, let's do the plaintiff's motions, and counsel, you may be seated until you're speaking to the court. Yes.
Yes, Your Honor. Plaintiff respectfully asks this court to exclude Exhibits 33 and 34. These exhibits are two emails sent from tenants of this subject property regarding drunk tenants leaving the ice house. These exhibits should be excluded for the following reasons. First, pursuant to Federal Rules of Evidence 403, the probative value of these exhibits are substantially outweighed by the dangers of unfair prejudice, confusion, and misleading the jury. There is no proof that what happened in these exhibits are substantially similar to the facts and circumstances of what happened on September 7th, 2024. There is no mention as to the landscape medians, the exposed sprinkler heads, or the lighting conditions. Furthermore, it will confuse the jury on who we are representing in today's case. These emails are in regards to Avery Potter and the ice house and have nothing to do with Jamie Leery, our client today.
Is that, I want to do one at a time because I want to do argument. I want to hear argument.
Yes, these are still just my arguments for just this one motion, yes. Additionally, under 404B, this is inadmissible character evidence. If these emails are introduced, it will incline the jury to base that the ice house acted in conformity with prior bad acts. And lastly, these emails are hearsay under Federal Rules of Evidence 801 and inadmissible under Federal Rules of Evidence 802. These are written assertions that are being made by tenants who are not here today in this court testifying and are being offered for the matter of the truth asserted, which is that there have been drunk customers leaving the ice house in the past.
Yes, Your Honor. By way of background, these emails were sent by tenants at the same location where the ice house was located. We believe that these are more probative than prejudicial, as it shows to the bar and the bartender, Avery Potter, that will testify here today, that they were put on notice. We're not bringing this in to show that they acted in conformity, but that they were aware prior to this of the habits of what their employees and this bartender that's going to be here today has done in the past. And to show that they know that they've been on notice and that they already been aware of what's happened with over serving their customers. Your Honor, it's not hearsay because we're not trying to bring this in for its truth. We're bringing this just to show that he has notice of other customers, other tenants complaining to him about the drunk customers that are leaving from the ice house.
Yes, Your Honor. Although the defense offers to bring these exhibits in to prove notice, it is still unfairly prejudicial to our client, as these tenants are not here today for the plaintiff to cross-examine them.
I'm trying to remember what hearsay exception notice comes under. What number is that? It's not.
It's not.
It's not. Unless you have a clear exception to the hearsay rules, then those emails written by some other person, classic hearsay. It's not being offered, it's probative, other than to show that this person acted in conformity or is a bad actor, so I'm aware, I read the depots, this wit has been deemed to be cheap. Okay, so I have to make sure that the jury only hears what they're supposed to hear and not from some people who are not coming into this courtroom to testify. Therefore, the plaintiff's motion in limine to exclude the emails is granted.
And Your Honor, whenever I may, I also have a second motion in limine.
I'm listening.
Plaintiff respectfully asks this court to limit the testimony of the defendant's expert witness, Lindell, in two respects. First, plaintiff respectfully asks to exclude Exhibit 73, which is a retrograde analysis. We ask that this court exclude this exhibit under Federal Rules of Evidence 702B and 702C. The facts and data is insufficient and it is based on unreliable principles and methods. Furthermore, this retrograde analysis was not conducted by Lindell himself. It was conducted by Christy Livingstone, an employee of Lindell. And Christy Livingstone is not here today to testify in court as to the facts, methods, or principles that she used. Additionally, Christy Livingstone's calculations are incorrect. Jamie Leery's blood was taken at 11:20 from the medical examiner's office, and she calculates these retrograde analysis at 11:30, as if that time, which adds to the retrograde analysis calculation. Furthermore, Dr. Lindell offers no information as to Christy Livingstone's qualifications, and it would be unfairly prejudicial since we cannot examine into her qualifications and the facts and methods that she inquired into this retrograde analysis.
Defense?
Yes, Your Honor. We believe that by laying a proper foundation, Mr. Lindell can say how Christy Livingston is a certified forensic toxicologist. She has been working for Lindell Consulting. She has done reports in the past, and Mr. Lindell has relied on these reports in other trials when he's had to show a retrograde analysis. And Mr. Lindell, when he testifies here today, he's going to prove that that is a common thing in the field of science that he is in as an ergonomist and a factor-based analysis, that they can rely on a forensic scientist's report to be able to base their own reports. They themselves don't need to be able to conduct it, but it's standard in the practice on that specific field.
Yes, Your Honor. Although Lindell has prior experience with this, this is beyond the scope of his expertise. He is a human factors expert and a certified ergonomist. He is not qualified today to testify as a forensic toxicologist or retrograde analysis to analyze these readings. This is beyond the scope of his expertise, as these courses that he has taken has been in the past 20 years. And Christy Livingstone today is not here today to testify exactly how she came with these calculations.
The court is aware of what experts can testify to under the Rules of Evidence of 702. There is no limit as to what an expert can read and testify to as long as they are able to base their opinion. And I'm sure that I've read the depots of Dr. Lindell, or the one depot, in Peach, I guess. We'll get to that when it's offered, if it's offered, but there's no limit to what an expert can read to reach their opinion. However, I will allow you wide latitude in cross-examination before this jury to have them determine, because I'm going to give them the expert witness before the experts. I'm not going to call them an expert. I'll just give them the instruction that expert witnesses are like other witnesses, with the exception that an expert can give an opinion in an area about which they believe the expert to be an expert. So I'm going to deny the motion to exclude the testimony of Dr. Lindell and let the jury make the determination whether or not they want to accept the opinion of this person testifying. Anything further from the plaintiff?
No, Your Honor. Thank you.
From the defense, any motions in limine?
Yes, good evening, Your Honor. The defense respectfully requests this court to exclude any and all testimony, exhibits, references, or arguments regarding two prior trip and fall incidents shown in exhibits 69 and 71, and any testimony regarding those incidents. So, Your Honor, the defense anticipates that the plaintiff will attempt to bring these incidents in to argue that Witter Development had notice of the danger of the subject premises. If you'd like, taking a look at exhibits 69 and 71, these exhibits are irrelevant under Federal Rule of Evidence 401 because they are not substantially similar circumstances to the incident that we have at bar today. So in these two incidents, they are not specific as to what median the alleged incidents happened on. Neither do they talk about a sprinkler head, which is the stipulated cause of the fall that we have here today. They also don't talk about the state of the person who fell in these incident reports. So we know that today Jamie Leery was intoxicated when he fell on that sprinkler head. So they are substantially different circumstances to what we have at bar and irrelevant under Federal Rule of Evidence 401. Additionally, if they are to come in for any other reason, it would be hearsay, because the only other reason that they could come in is to show that there was an actual danger in the parking lot. And that would be offered to assert the truth of the matter. And that is a classic hearsay, and it wouldn't be inadmissible.
Rebuttal?
Good evening, Your
Good
Honor.
evening. I was wondering when you were gonna talk to me.
Your Honor, the plaintiff does not offer these reports into evidence. The plaintiff will use them in the examination of Mr. Witter and reserves the right to offer them if the need arises. Notice is a contested element in this case, and the defendant has already conceded a duty to discover dangerous conditions on his property. Rule 401 asks only whether this evidence bears on that element, and it does. Defendant treated these reports as notice when it received them. Mr. Witter testified that in response to them, the company painted the curbs and the parking bumpers in this lot. It read them, it considered them, and it acted on them. It cannot now tell this court they are irrelevant. Defendant's motion assumes the condition is a single sprinkler head on a single median. It is not. The condition is the darkness, and the reports are the defendant's own record of it. Exhibit 69 records the lighting as limited with several areas dim. Exhibit 71 records it as dark. Those entries are the defendant's own form. Nor is this hearsay. Plaintiff does not offer these reports for the truth of what any patron said, but to prove the defendant was told. And under Rule 801C2, that is not hearsay at all. The entries that matter are the defendant's own statements of party opponent under Rule 801D2D. Should the court have any concern about the patron narrative at the bottom of the form, plaintiff will accept its redaction and in a limiting instruction confining this evidence to notice. Plaintiff asks that the motion be denied.
Okay, if I heard correctly, plaintiff just claimed that these incidents are statements by a party opponent. Excuse me, let me retract that. We are willing to accept that these incident reports are with regard to lighting. So if they are offered to this jury, the only reason that they may be offered would be under FRE 105 with respect to the adequacy of the lighting. But if they are offered for any other reason, then they are inadmissible because they don't talk about specifically sprinkler heads or anything with regards to that. So that is my rebuttal, Your Honor.
Rebuttal?
With regards to the medians being dissimilar, every median was built to the same plan. One irrigation system ran beneath all of them. Dead all for a decade. And when the defendant priced the fix in 2014, it priced the whole lot. The geography is not dissimilar. Additionally, dissimilar incidents under Exhibit 71 came 10 weeks before this fall. At 9:10 in the evening, Mr. Leery fell at 9. Customer crossing this lot at 9 o'clock who could not see, who fell in the landscape median. Differences go to the weight.
The only problem I have with you trying to introduce evidence of what others did, other people's accidents. People are different. Some people just are clumsy, they fall. And so you're saying, well, it's because the median and the sprinklers are 2 inches above where they're supposed to be. The lighting is relevant, but the fact that two other people fell and that there's emails from the bartender and other people saying it's dangerous and things like that, none of that is relevant to what happened to Mr. Leery. other than it's a dark condition, thereby creating a dangerous and hazardous atmosphere and environment to which he fell. That's your argument. The defense argument is he was drunk. It's slapping him down, you know. So I think to the extent that you're gonna ask Mr. Witt about prior people falling and things of that nature, I'm trying to keep this case relevant only to what happened to Mr. Leery, okay, on September 7th. And so therefore, to the extent that you want to introduce those two prior falls, people slipping and falling, it's not relevant in this case. So I'm gonna grant the motion. If you can find a way to redact what, you know, that the lighting is bad, I'm letting that in. Okay, it's dark, I saw the exhibits, but those exhibits 69 and 71 that go to other people tripping, slipping and falling, no relevance here. And it just shows, you know, somebody sued him before. We have that problem with a witness, so I gotta deal with that eventually. So to that extent, your motion is granted
Thank you, Your
to
Honor.
exclude those. Anything else?
Additionally,
Yes, ma'am.
excuse me, additionally, we have a second motion in limine. And this one is regarding the subsequent, after the fall happened, the Logan Witter went out to the subject parking lot, and they fixed the sprinkler head. And by fixed, I mean they pushed the sprinkler head back into the ground.
So remedial measures, you don't want that.
Remedial measures, yes, Your Honor.
What exception does that come in under?
Your Honor, the plaintiff will not offer this repair in its chief as proof of negligence. Rule 407 reaches measures taken after the injury and reaches nothing else. Exhibit 68 is from February 2014, a decade before this fall, and the rule does not touch it. And what matters about September 21st is the condition, not the cure. When the subcontractor examined this head, he said it never retracted since the last time the sprinkler system was run. And that system had been over for 10 years. That is evidence of how long this head was protruding, and duration is a constructive notice. A blanket order would rename plaintiff's notice evidence of a repair.
Well, who wrote did Mr. Witt, I'm trying to remember the depot, did Ms. Witt testify to that in her depot?
Yes, yes, Your Honor.
That, but they're constantly making repairs or you can add, I'm not gonna let remedial measures come in, but you can ask generally, what's the maintenance in that area? Like, have you changed anything, you know? How does a change occur? Something to that matter, but just to say they went out and they just pushed it down with their foot, somebody could have just pulled it up. You just never know. So I'm giving you some broad leeway in your cross-examination of Ms. Witt, but that exhibit, was that number 68?
No, Your Honor, it's not an exhibit, but rather testimony regarding it.
You can ask about, you know, general maintenance and repairs in the area, but not that right after this accident, this incident, that somebody went out and fixed it. So that's not coming in. So that motion is granted.
All right, thank you, Your Honor, and that will be all for the defense tonight.
So just to recap, the following exhibits are out, 33, 34.
Yes.
And then 73 comes in, right? You wanted to exclude Dr. Lindell's talking about exhibit 73, and I denied that based upon 702. Then exhibits 69 through 71 about the trip and falls or the slips and falls or whatever they were doing out there. I granted that, so those are out. 69 through 70 and 71, I think. And then remedial measures out. Right? Everybody clear?
Yes,
You should go in these areas where I made my rulings. I'm not gonna look at you and smile in front of the jury. So don't try to get it in the back door, okay? Anything further from the plaintiff before we begin openings?
No, Your Honor, we're ready to proceed to openings.
From the defense, before we proceed to open.
Nothing more from the defense, Your Honor.
Now, is the defense going to follow the plaintiff, or do you want to reserve? Are you going to reserve, or are you going to go right into it?
Go right into it. I
Excellent.
believe, Your Honor, Your Honor, we have, we'll be changing from the screens. So it'll just be a brief moment, just connecting the.
Not a problem, I just don't want my jurors to sit there all evening while we're messing
We'll make
with
it brief.
technology, okay? I'm old school, you get transparencies and lamps. All right, good evening, members of the jury, I apologize for the delay. There were some motions that the attorneys and I needed to go over. So I appreciate your patience, and I will be respectful of your time. At this time, the attorneys are going to make what is called an opening statement. An opening statement gives them an opportunity to tell you what they believe the evidence in this case is going to be. I'm going to ask you to listen very carefully, very closely. You may take notes, but keep in mind that your notes are for your eyes only, not to be shared and say, well, I wrote this down. You know, it's to help you remember when you start your deliberations in this case. But remember, what the lawyers say is not evidence, and you cannot consider what they say to be evidence. But listen carefully, because it's to help you understand how this case is going to proceed. Each side has the same amount of time, and at this time, because the plaintiff has the burden of proof, the plaintiff gets to go first. You may proceed.
Thank you, Your Honor. May it please the court, counsel. Members of the jury. This case is about choices. Choices that the defendant in today's case chose to make. Throughout the course of today's trial, we will learn that the defendant knew about sprinkler heads sticking out of their parking lot for over 10 years. In their response, it's just a couple of sprinkler heads sticking out of the ground, right? But on the evening of September 7th, 2024, one of those sprinkler heads took the life of Jamie Leery. Mr. Leary's 76th birthday was only 3 days away. But little did he know that because of an uncorrected hazard, that he would never make it to that birthday. Good evening, my name is Derline Desjardins, and along with my co-counsels, Francesca Baleanu and Jonathan Frechter, we have the privilege of representing the plaintiff in today's case, Riley Leery, individually and as the administrator of his father's estate, Jamie Leery. This is Riley. Riley is the plaintiff and the administrator of Jamie Leery's estate. Now, what that simply means is that Riley is here on behalf of his father because his father's not here. His father is dead. Riley has brought this claim against the defendant to hold the people responsible for his father's death accountable. But in order for us to fully understand why we are here today, let's first meet Jamie Leery. This is Mr. Leery, Riley's father. Mr. Leery was more than just the plaintiff's father. Mr. Leery was a grandfather, a former professor of over 40 years, a mentor, and a friend. Mr. Leery spent most of his life educating students and caring for his family. And on the evening of September 7, 2024, what was supposed to be an evening celebrating his upcoming birthday and making memories with his son ended in tragedy after Mr. Leery suffered a deadly fall. But first, to fully understand why we are here today, we must first go back. Not to the evening of Mr. Leery's fall, but to 10 years prior to when the defendant first learned about the dangerous condition that ultimately took the life of Jamie Leery. It is February 14th, 2014, and the owner and developer of Witter Development, Logan Witter, is making some changes to the shopping center where the Ice House restaurant is located. The developer decides to replace the grass in the medians with mulch because the sprinkler system is too expensive to maintain. This change means that the sprinkler heads in the ground will no longer be needed. During this process, the developer receives an email from their chief financial officer with an estimate of $4,000 to $5,000 to properly remove those sprinkler heads from the ground. But the developer refuses to pay for those repairs and instead responds to that email by saying, it's just a couple of sprinkler heads sticking out of the ground, right? So those sprinkler heads remain in the ground as years pass. It is now July 23rd, 2022. And Avery Potter, the general manager of the Ice House restaurant, becomes concerned as she watches customers leave the restaurant and enter that parking lot, the defendant's parking lot. This is the defendant's parking lot. The manager sees a problem. The parking lot is too dark. Concerned that someone could possibly get injured while walking through this parking lot, the manager reaches out to the developer and informs them of her concerns and asks them to do something about it. But nothing changes, and the parking lot remains the same. It is now August 1st, 2024, more than 2 years later, and the manager, still concerned about the conditions of this parking lot, reaches out to the developer yet again, but this time, the email is more urgent. This time, the manager informs the developer that customers have already fallen or almost fallen while walking through their parking lot, and again asks them to do something about this. This time, the developer responds, but not by putting up more signs in the parking lot, not by removing those exposed sprinkler heads, but by putting up a sign. This sign. This is the one sign that the developer posted in that entire parking lot after receiving those complaints. Now, the developer will take the stand later today, and so we'll sit right here. And she will likely try to tell us that this sign made her parking lot safe for customers. But members of the jury, we ask that you apply your common sense, and the evidence will show that this sign did nothing to warn customers of those exposed sprinkler heads, does nothing to warn customers of the poor lighting conditions, does nothing to make the parking lot reasonably safe, and this sign was posted nowhere near where Mr. Leery fell. Fast forward to the evening of September 7th, 2024. Mr. Leery and his son are inside the Ice House restaurant celebrating Mr. Leary's upcoming 76th birthday. Before we talk about what happens next, it's important to address a few things that the defense will likely try to tell us later today. The defense's expert, Lindell, will come here. They will likely try to tell us that Mr. Leery had too much to drink on this day that he was celebrating his upcoming birthday. Pay close attention to how this same expert will be forced to admit that they are not a toxicologist, and that they cannot say definitively that alcohol actually caused Mr. Leary's fall to happen. The defense will also come up here later and will show you 3 photographs of the 3 different receipts from 3 different restaurants that Mr. Leery visited on the night he was celebrating his upcoming birthday. These receipts will show that Mr. Leery had a couple of drinks throughout the day. But pay attention to what else these receipts will show. These receipts will show that these drinks were consumed throughout the duration of 9 hours. And Mr. Leery had more than just drinks. He also ate that night. Now, as Mr. Leery and his son leave the restaurant shortly before 9 p.m., they begin walking through the parking lot to get to their car. As they are walking towards their car, Mr. Leery suddenly comes across a puddle of water in the pavement. So, to avoid stepping in that water, Mr. Leery does what any person would do. He steps to his left and steps up onto a landscape median. This median. This is the median that Mr. Leery stepped onto to avoid stepping in that puddle. But unbeknownst to Mr. Leery, there's a danger hidden within this landscape median. It's hard to see at first, but if you look closely, there's a sprinkler head sticking up out of the ground a couple of inches right here. As Mr. Leery steps onto the median, he begins walking, and suddenly his foot trips over this exposed sprinkler head, and he falls forward, slamming his head onto the pavement. Riley rushes over to his father's side. The manager hears Riley scream for help and rushes over to find Mr. Leery lying on the pavement. EMS arrives to the scene, but it's too late. Unfortunately, that same night, Mr. Leery succumbs to his injuries and dies, leaving behind 3 kids and 6 grandchildren. It is because of this that we, the plaintiffs, have brought forth this claim of negligence against the defendant, Witter Development. And in doing so, we carry the burden of proving by a preponderance of the evidence, which simply means more likely than not that the defendant knew or should have known about the dangerous condition, they failed to make that condition reasonably safe, and as a result, caused the death of Jamie Leery. And make no mistake, members of the jury, we will meet that burden here today. To meet our burden, we will call some witnesses to the stand. We will call Riley. Riley will take the stand and he will describe that day that he had celebrating his father's upcoming 76th birthday and the moments leading up to his father's fall, including the conditions in the parking lot that night. We will then hear from Avery Potter, the general manager of the Ice House restaurant. The manager will take the stand and she will explain to us how she became concerned as she watched customers leave the restaurant and enter that dark parking lot, and how she reached out to the developer multiple times, and how nothing was ever done to address her concerns. The manager will also describe to you all how she had a chance to observe Mr. Leery on the night that he was inside the restaurant, and how based on her observations, Mr. Leery did not look intoxicated at all. Finally, we will hear from Cameron McPhee, our premises safety expert. Our expert will take the stand and explain to us how a sprinkler head sticking up out of the ground a couple of inches high poses a tripping hazard to pedestrians, and how any reasonably prudent property owner would have taken action to correct those conditions after receiving notice. So as you listen to the testimony and evaluate the evidence, consider whether the defendant kept their parking lot reasonably safe for customers like Jamie Leery. And at the end of this case, my co-counsel, Francesca Baleanu, will stand before you. And she's going to tell you everything that we've seen and heard here together. Ms. Baleanu asks that you render the only verdict that is supported by the facts, the evidence, and the law. And that is a verdict finding the defendant, Witter Development, negligent, because the evidence will show that they knew about those exposed sprinkler heads for over a decade, and they received multiple complaints from Ms. Potter and how they did nothing to address those concerns. And members of the jury, when you see something, you say something, but most importantly, you do something. Witter Development did nothing. And that is what ultimately caused the death of Jamie Leery. Thank you.
Thank you. Bench, you may see.
Yes, sir.
As I said, technology. You may be seated, counsel.
This is the court, opposing counsel. Members of the jury. My name is Louis Kalil. Alongside me is my co-counsel, Briana Garcon, and we represent Witter Development, defendant in this case. Now, a moment ago, you heard several things about Logan Witter. I want to introduce you. It's Logan Witter. She's the owner of the property where the Ice House is located. She's owned that property for over 25 years. And Ms. Witter, she has several duties. Her duties is looking over the tenants, making sure that her premise is safe. And you're gonna hear testimony here today that Witter not only sent maintenance workers to go out there quarterly, you're gonna hear testimony that whenever she was made notice of any defect, any complaint, she sent someone out to get it fixed. Whether it be the lights, there's a curb that you can't see, she would send someone out to fix it. This Witter, she was reasonable. She wanted to make sure that her location was safe. And members of the jury, it's unfortunate what happened to Jamie Leery, but that doesn't make my client liable. And plaintiffs, they came up here and they told you a little bit of what happened with Jamie Leery that day, or when they were in the ice house, but I want to talk about what happened on September 7th, full day. So, Jamie and Riley Leery, they went out on September 7th to go have some drinks and visit a couple of bars. Now, Jamie Leery, he has one drink. His main drink is old fashions. Essentially, what an old fashioned is, it's a little bit of bourbon, sugar, bitter, and ice. Now, on September 7th, they went out to the first bar, which is Blue Water Grill. There, that's where Jamie Leery had his very first old fashioned on that day. After leaving the Blue Water Grill, they went to Hell's Kitchen. When Jamie Leery got there, he ordered another old fashioned. And before he left, Jamie ordered another one. 3 old fashions he's had at that point. And then from there, Jamie Leery and Riley, they decide to go to the ice house, where Witter Development is the owner of the property. And you're going to see that when they parked their car that day, where the ice house was located, they had a route that they could have taken. And it was directly through a sidewalk. But instead, they decided to go through the parking lot that day. And when they finally got to the ice house, Jamie Leery ordered another old fashioned. In the middle of the night, he ordered his 5th old fashioned. And at some point, Jamie Leery had to use the restroom. Members of the jury, Jamie Leery came back. You're going to hear about today 2 witnesses that witnessed Jamie Leery having difficulty walking. He stumbled and had difficulty getting on a chair. Now, one of those witnesses was Riley. When Jamie Leery was going to get back on his chair, he stumbled. You're going to hear also from the bartender, Avery Potter. That night, she saw Jamie Leery coming back from the bathroom, stumble. She also saw him stumble getting in that chair. And that bartender, she asked Jamie Leery, "Are you sure you can have another old fashioned?" Jamie Leery waved, "Yeah." And the bartender, she handed him his 6th old fashioned that night. Now, you're going to hear that that bartender, she was aware she has a duty to be able to stop serving alcohol to her patrons, to her customers. And she has to make sure that whenever she sees these signs, stop. But she didn't. Now, members of the jury, I want to tell you about what you're going to hear from the testimony here today. You're going to hear from multiple witnesses. One of them is Riley Leery. Riley Leery is going to walk you through and tell you all the drinks that him and his father had that day. And he's going to tell you about where they parked and what route they took. He's going to tell you about a sign that was posted right in front of the ice house, and he was made aware of this afterwards. And he's going to tell you that, he saw his father stumble are having difficulty getting on that chair that night, but they were having a fun time. And you're gonna hear that Leery, he sent out a text message to that bartender. She told him to come meet their lawyers so she can not avoid getting tangled up in this. Now that bartender, you're also gonna hear from that bartender here today. And that bartender, she's gonna take the stand. She's gonna tell you that she has a duty. She knows she has to stop serving alcohol. Once she sees these signs, she's gonna tell you that she saw Jamie Leery stumble not once, she saw him stumble twice. Still continues serving him alcohol. And now that bartender, members of the jury, she knows that other customers have had issues in the parking lot. And she knows that there's a sign posted right out front of her business telling customers to take the sidewalk. She's good friends with Jamie. She was good friends with Jamie Leery. She didn't tell Jamie Leery that day to take the sidewalk. So she's gonna tell you that she saw Jamie Leery crossing through the parking lot, and she saw it to the point where Jamie Leery tripped and fell. Now, members of the jury, that bartender, you're also gonna hear from her how she received that text message from Riley Leery, and how she knows that she could avoid being tangled up in this whole mess. She won't be sued if she would help them testify for them. You're also going to hear today from Cameron McPhee. Cameron McPhee is an expert in landscape. Members of the jury, I urge you to pay close attention to the testimony of Cameron McPhee. Because when he takes this stand, my co-counsel is going to ask him a couple questions. She's going to point out to you that Cameron McPhee knows my client. Cameron McPhee has threatened my client. Cameron McPhee has a vendetta against my client. Cameron McPhee has sued my client. And to top it off, Cameron McPhee didn't tell the plaintiffs that he knows my client. And he volunteered to give a report against my client. Members of the jury, the court will instruct you that if a witness's testimony shows any bias or uncredibility, you can disregard that testimony. Cameron McPhee's report, you're going to hear that he can't point to one city violation about the lights at the parking lot. He can't point to one city violation about a sprinkler system. Finally, you're going to hear from Dr. Dylan Lindell. Dr. Dylan Lindell is an expert in ergonomics and factor-based analysis. Essentially, what that means is that he checks the surroundings and the way that the surface is in the area and the movements of one person's body, how they react to that area. And Mr. Lindell will show you in his report, they came up with two opinions. First, that where the sign was located, that parking lot, any reasonable customer coming out of that ice house would have seen that sign. And what that sign depicted showed that there's a danger. Take the sidewalk. And he will tell you that Mr. Leery disregarded that sign. In his other opinion, he's going to tell you that Mr. Leery's alcohol levels at the time of the accident was above the minimum requirement. That because his alcohol levels were above the minimum requirement, that affected his perception, his mental state, and his stability. Now, members of the jury, at the end of this trial, my co-counsel, Briana Garcon, will come up here and she'll give you a recap of everything you heard here today. And the court will instruct you on the law. And finally go and deliberate. We'll look at all the facts, all the testimony that you heard here today. And it's unfortunate what happened to Jamie Leery. My client, not responsible for it. My client made reasonable measures to keep that parking lot safe and warn customers who were mainly coming out of his house. And that's why we believe that when you come back from deliberation, you come back with a verdict of not liable. Thank you.
Thank you. All right, this plaintiff may call the first witness.
Your Honor, the plaintiff calls Riley Leery to the stand.
Leery, why don't you approach the witness stand, remain standing, and the court will swear you in. Please raise your right hand. You solemnly swear the testimony you will give in this case will be the truth? Yes. You may be seated. Please state your name and then spell your last name so that the jurors will know how to spell.
Riley Leery, R-I-L-E-Y-L-E-R-Y.
Why?
Good evening. Can you please introduce yourself to the jury?
Yeah, I'm Riley Leery, 35, and I live in Atlanta.
Your Honor, permission to publish for the jury Plaintiff's Exhibit 1. Riley, who is this?
That's my dad.
What did your dad do for a living?
Dad was a professor at the University of Wilmington where he studied Shakespeare.
Where were you on September 7th of 2024?
I went to go visit my dad to celebrate his birthday.
What did you two have planned for that day?
We went to lunch at the Blue Water Grill.
How was your dad physically there?
That was great. We're having a good time celebrating his birthday. He ate lunch.
What was the next stop?
Next stop was Hell's Kitchen, where we went to go watch some college football.
How was your dad physically there?
That was great. He was having a good time at the bar. He had a few drinks. But he was his normal self. He wasn't slurring his speech, wasn't stumbling.
What was the last stop?
Last stop was the Ice House.
Your Honor, permission to publish Plaintiff's Exhibit 9. Riley, what is this?
The red circle is where we parked my car, and the blue circle is the Ice House.
Your Honor, permission for my witness to step down to explain the exhibit?
You may. But keep your voice up while you're away from the witness stand.
How did you get from the car to the ice house?
Walked directly from my car to the parking lot to the Ice House.
How was your dad physically when he got inside?
That was great. He was his normal self. He, at one time, had a hard time getting into his chair, but he was good. I wasn't slurring his speech, just having a good time celebrating his birthday.
From what you saw, that difficulty, was that due to impairment?
No.
Let's talk about when you got outside. Counsel, I'm showing you what has been previously marked as Exhibit 12. Your Honor, may I approach? May I approach witness? Thank you. Riley, I'm showing you what has been previously marked as Exhibit 12. You recognize this.
Yes.
What is it?
That's the path we took when we left the ice house.
Does it fairly and accurately show the path you took that night?
Yes.
Your Honor, plaintiff offers what has been previously marked as Exhibit 12 into evidence as plaintiff's Exhibit 10.
Do you have the electronic version or you can just?
May we publish for the jury?
Absolutely. Just
Excellent,
publish.
thank you. Riley, when you got outside, what did you notice?
It was really dark, couldn't see anything.
How far were you walking away from your dad?
I was just a couple of feet behind me.
How was your dad walking?
Dad was great, he normal self.
And as you got closer to the car, what did you notice?
As we got closer to the car, we saw a puddle.
Counsel, I'm showing you what has been previously marked as Exhibit 14. Your Honor, may I approach? May I approach witness? Thank you. Riley, I'm showing you what has been previously marked as Exhibit 12. You recognize this.
Yes.
What is it?
That's the puddle my dad had to avoid.
Does it fairly and accurately show the puddle
Yes.
that night? Your Honor, plaintiff offers what has been previously marked as Exhibit 14 into evidence as plaintiff's Exhibit 11.
Based upon the stipulation, you may do so and you may publish.
Thank you.
But counsel, if you'll leave those copies with the court so that when the jury begins their deliberations, they can take the actual exhibits back with them.
Excellent. I can grab them and bring them over to you.
Please do.
Absolutely.
Members of the jury, we can't take the screen into the jury room, so we're gonna make sure you have copies of the exhibits so that you can refer to them during your deliberations.
May I approach? They're two pre-admitted.
Okay.
Thank you.
And we'll just leave them here and I'll put them with the other exhibits. But if you need to refer to anything that is in evidence, you can always approach the bench and see.
Thank you, Your Honor.
You're welcome.
Riley, as your dad stepped around this puddle and onto the median, what did you see?
After my dad stepped around the puddle, stepped onto the median, he fell, tripped.
What did you do then?
I rushed over to him and saw he was bleeding, and I rushed over to him, saw he was bleeding. I looked at the ground and I didn't see anything, but then I saw a sprinkler head right near him.
Prior to seeing the sprinkler head, how was your dad?
Dad was great. Was his normal self. He went to celebrate his birthday and we had a good time.
Allow me just a moment. Once he stepped onto the median, around the puddle, he then tripped. What happened then?
Yeah, after Dad tripped, I asked him what happened. He said he tripped over something. This is when I looked and found the sprinkler head after, and he was taken by paramedics later.
At any point in time, had you seen that sprinkler head before your dad fell?
No,
Why couldn't you see it?
it was camouflaged in the ground. It was so dark outside we couldn't see anything.
I have no further questions, Your Honor.
Cross-examination.
Your Honor, do you want all the exhibits each time that commit them, or like once I'm done, I just give it to
They've
you?
been pre-admitted, I just need to get the smaller pictures for the jury's perusal.
Yeah.
But you can publish any exhibit that the court has admitted. Members of the jury, how y'all doing for bathroom breaks or anything like that to set the court now?
Good afternoon, Mr. Leery.
Hello.
Mr. Leery, you and your father, you went to a couple bars that night, correct?
Yeah, that's correct.
And showing the court, what's been pre-marked as plaintiff's exhibits 6 and 7. Now, Mr. Leery, at the Blue Water Grill, your father had one old fashioned, correct?
Yeah, that's correct.
And afterwards, you guys went to the Hell's Kitchen, correct?
Yeah, after we had some food into the Hell's Kitchen.
And at Hell's Kitchen, your father ordered 2 old fashions there.
Yes, that's correct.
And at that point, that's already been 3 old fashions.
That's correct.
Now, your father mentioned to you that you wanted to go to the ice house,
Yes,
and you've never been to the ice house.
never been.
And your father told you that he knows the bartender there, correct?
Yes,
Showing the court what's already been pre-admitted as plaintiff's exhibit 9. Now, Mr. Leery, a moment ago you indicated that the red circle is where you parked your car, correct?
yeah, that's correct.
And the blue circle is where the ice house is located.
Yeah,
And Mr. Leery, around the side of the building where the roof is, that's where the sidewalk was at, correct?
yep.
Now, you didn't take the sidewalk.
No, we did not.
Said you took to the street.
Yeah, we took the easiest path to the car.
And Mr. Leery, after September 7th, you were made aware that there was a warning sign posted in front of the ice house, correct?
Yeah, during my deposition, I was made aware of the warning sign.
Showing the court what's already been pre-admitted as plaintiff's exhibit 3. Oh, plaintiff's exhibit first 8. And now, this is the ice house, correct?
Yeah, that's correct.
And at the ice house, your father ordered 1 old fashioned when he got there.
Yes,
And towards the middle of the night, your father ordered his 5th old fashioned.
yes,
And now, at some point at that time, your father went to use the restroom.
that's correct.
And when he came back, you didn't see him stumble coming out of the bathroom.
No, I didn't see him stumble.
You saw him having difficulties getting on the chair.
Yes,
You didn't tell him to stop drinking old fashions at that.
no, I think the 75, the chair didn't have to do with his drinking.
Well, after seeing him stumble, the bartender still gave him his 6th old fashioned, correct?
That's correct.
Now, you and your father left around 9 p.m., correct?
Correct.
And when you walked out the ice house, no one told you to take the sidewalk.
That's correct.
And no one told you that no one told you about the sign that was in front of you.
Yeah, no one told us about the sign.
You and your father walked straight through the parking lot.
Yeah, that was the closest path to get to the car.
Now, Mr. Leery, you would agree with me that when you trip, you try to, stop the fall, correct?
Sometimes.
Well, you were walking right behind your father on that day, correct?
That's correct.
And moments before he tripped, you saw how he tripped, correct?
Yeah, I saw he tripped and it sounded like his head split open.
Mr. Leery, you didn't see him, he didn't put out his arms out to stop the fall.
No, I did not see that.
Mr. Leery, I want to talk to you about after September 7th. You reached out to Avery Potter, who was the bartender at the ice house,
Yes,
and you told Avery Potter to help you with the lawsuit to avoid getting tangled up into this, correct?
Yes, that's correct.
Showing the court. Showing what's already been pre-marked as Exhibit 37 to opposing counsel.
No objection, Your Honor.
What's the number again?
This is Exhibit 37. May I approach the bench? Approaching the witness. You know Exhibit 37?
Yes,
Exhibit 37 is text messages between you and Avery Potter.
yeah, that's correct.
And Exhibit 37 is a fair and accurate depiction of the text messages between you and Avery Potter.
Yes,
Your Honor, at this time, the defense moves Exhibit 37 as Defense Exhibit 1.
It's already in evidence and you may publish at this time.
Now, you sent this text message to Avery Potter, correct? And Avery Potter responded to you, absolutely.
Yes.
No further questions.
Read it back.
Riley, do you recall any of the other bars warning you prior to leaving?
no, none of the other bars, warrant us prior to leaving.
No further questions, Your Honor.
Mr. Leery, you say. Next witness, please.
Plaintiff calls Avery Potter to the stand.
Hi. Good evening. You please approach the witness stand and remain standing. The court will swear you in. Please raise your right hand. You solemnly swear or affirm the testimony you are about to give will be the truth.
I do.
Seated. Need you to state your name and spell your last name for the record.
Hello, I'm Avery Potter, Potter.
Remain quiet.
Good evening, Ms. Potter. Could you please introduce yourself to the jury?
Hello, I'm Avery Potter and I'm 35 years old.
What do you do for a living, Ms. Potter?
I am the general manager of the Ice House in Wilmington.
What is the Ice House?
The Ice House is a bar and restaurant here located in Wilmington.
What do you do at the Ice House?
I am the general manager. I was initially hired as a bartender.
Who's responsible for keeping the Ice House safe?
Witter Development is responsible for keeping the Ice House safe. They own the shopping plaza that the Ice House is located in.
What are your duties and responsibilities as general manager?
As the general manager, I'm responsible for maintaining daily operations, overseeing employees, as well as the safety and cleanliness of the restaurant.
Prior to working as the general manager, have you held any other positions at the Ice House?
I was originally hired as a bartender, and then about a year into that, I was then promoted to be the shift manager. And then 5 years ago, I was promoted to be the general manager of the entirety of the restaurant.
Did you have to receive any trainings in order to become a bartender?
Yes, the HABC was responsible and gave me trainings so that I know how to do the sale and also the signs of overconsumption of alcohol.
You're under permission to publish Plaintiff's Exhibit 5? Ms. Potter, what is this?
This is the training that was provided to me.
What did this training teach you?
The training taught me about the sale of alcohol as well as signs of overconsumption and when to stop serving guests.
What are some signs of intoxication?
Some signs include slurred speech, blurred vision, as well as loss of balance, and then also delayed decision-making.
Now I want to talk to you about why we're here today. Do you know why we're here?
Yes, I do. On September 7th, 2024, a dear friend of mine lost his life while falling in the parking lot of the ice house.
I'm so sorry for your loss, Ms. Potter. How did you come to know of Mr. Leery?
Mr. Leery was a lifelong friend of mine. He originally taught me in one of my classes at Wilmington State.
Your Honor, permission to publish Plaintiff's Exhibit 1? Ms. Potter, who is this?
This is Jamie Leery.
How would you describe your relationship with Mr. Leery?
Mr. Leery was a long-term client of the ice house as well as a long-term friend of mine.
Did you stay in contact with Mr. Leery after you left Wilmington State?
Yes, I had. He had advised me of all my classes there, but also he gave me the advice originally to go and work at the ice house after graduation.
Now I want to talk to you about the evening of September 7th, 2024, when Mr. Leery fell. Were you working at the ice house on that night?
Yes, I was on shift that night.
Did Mr. Leery come into the restaurant?
Yes, he had.
Who was with Mr. Leery?
On that night, Riley had come in with Mr. Leery. Riley and him, if I recall, Jamie's birthday was that next week, so they had come in to celebrate.
What did Mr. Leery and his son have to eat that evening?
That night, Jamie and Riley had a cheeseburger, a buffalo chicken sandwich, 2 sets of fries, and a ranch as well.
What did they have to drink?
Jamie and Riley had 3 beers, 3 old fashions, some iced teas, and some waters as well.
Did you get an opportunity to observe Mr. Leery inside the restaurant that night?
Yes, I had.
And based on your observations, did Mr. Leery appear intoxicated at all?
No, not at all. He had stumbled a little bit, but he was an older guy, about 75, so it was common for him.
Now I want to talk to you about what happened once Mr. Leery and his son left the ice house. When they left, what did it look like in the parking lot?
It was 9 p.m., so it was extremely dark outside, and I had walked out to walk them out.
As you walked them out, were you able to watch them walk to their cars?
Yes, I stepped out on the sidewalk outside of the ice house so I could watch them walk out to their cars. I was going to wish him a happy birthday, to say goodbye, which I'm glad I did because that was the last time I'd be able to say goodbye to him.
As you watched them walk to their car, did you see Mr. Leery stumble at all?
No, not at all. When he was walking out to his car, he hadn't stumbled. It wasn't until he fell that I saw him disappear from my line of sight.
When you saw Mr. Leery disappear, what did you do?
I immediately rushed over. I then heard Riley yelling, so I came over as quick as I could. I walked over and Jamie was on the ground. He was holding his head and he was bleeding. And he said that he tripped over something.
Now, after Mr. Leery said he tripped over something, were you able to see what he tripped over?
I hadn't originally seen it. It was really dark, so I could really barely see anything. And I was looking on the ground and then suddenly I saw it was the sprinkler head. It was sticking up out of the ground.
Now showing opposing counsel, it's been previously marked as Exhibit 61. Permission to approach. Permission to approach, please.
And you may publish there.
Yes, Your Honor. Ms. Potter, I'm showing you it's been previously marked as Exhibit 61. Do you recognize this?
Yes, I do.
How do you recognize it?
It's the landscape median and sprinkler outside of the ice house.
Is it a fair and accurate depiction of the sprinkler head?
Yes, it is.
Has it been changed or altered in any way?
No, it's not.
Plaintiff now offers Exhibit 61 into evidence as Plaintiff's Exhibit 12.
Any objection?
No objection, Your Honor.
Ms. Potter, would it help you describe what this photograph is if you were able to step down?
Yes.
Your Honor, permission for this witness to step down?
Watch this witness to step down. You goes up while I'm listening.
Ms. Potter, what does this photograph show?
So if you're really looking over here, in this red circle, you can see where the sprinkler head is and the landscape median outside of the ice house.
Prior to the night of Mr. Leery's fall, had you ever seen that sprinkler head before?
No, I had not.
Why weren't you able to see that sprinkler head?
It was usually really dark and above here, the lights were out, so I couldn't see it.
Thank you, Ms. Potter. You may retake the stand. Now I want to talk to you about the lighting conditions in the parking lot that night.
Your Honor, permission to publish Exhibit 2. Ms. Potter, what does this show?
That is at a similar time of night to when Jamie fell. It's outside of the ice house.
Now, you previously mentioned that the parking lot was dark on the night of Mr. Leery's fall. What did it typically look like in the parking lot?
It was typically pretty dark. The lighting was always an issue, so it's really dark outside.
You know Logan Witter?
I do.
Who is Miss Witter?
Ms. Witter is the owner of the shopping center that the ice house is located in. She's also the owner of Witter Development and the defendant in today's case.
Did you ever make any complaints to Miss Witter about your concerns regarding the parking lot?
Yes, I had. I originally had sent an email at first on July 23rd, 2022. And then I sent a second email complaining about the lighting in the parking lot on August 1st, 2024, about a month before Jamie's fall.
If I were to show you that first email that you sent to Miss Witter, would you be able to recognize it?
Yes, I would.
Now showing opposing counsel who has been previously marked as Exhibit 30, permission to approach. Permission to approach the witness. Ms. Potter, I'm now showing you what's been previously marked as Exhibit 30. Do you recognize this?
Yes, I do.
How do you recognize it?
It's the first email that I sent to Logan Witter.
And when was this email sent?
I sent it on July 23rd, 2022.
Has it been changed or altered in any way?
No, it has not.
Plaintiff now offers Exhibit 30 into evidence as Plaintiff's Exhibit 13.
That's granted and you may publish.
Ms. Potter, what did you send to Ms. Witter in this first email?
In the first email, I was telling Logan about how dark the parking lot was and that I was scared for the guests and complaining.
Did Ms. Witter do anything about the parking lot after receiving this first email?
No, she had not.
Now let's talk about the second email that you sent. Now showing opposing counsel, Exhibit 31, permission to approach the bench.
You may approach the witness.
Ms. Potter, I'm now showing you Exhibit 31. Do you recognize this?
Yes, I do.
How do you recognize it?
This is the second email that I sent, again complaining.
Is it a fair and accurate depiction of the second email that you sent?
Yes.
Has it been changed or altered in any way?
No.
Plaintiff now offers Exhibit 31 into evidence as Plaintiff's Exhibit 14.
You may publish unless there's any objection.
No objections, Your Honor.
Ms. Potter, what did you send to Ms. Witter in the second email?
In the second email, I'm telling Logan again about the lighting in the parking lot and that it's a problem, that she should do something about it. Telling her about how it's dangerous and how I've had guests who have fallen down or almost fallen down.
You previously mentioned that guests have fallen down or almost fallen down while walking through this parking lot. About how many guests?
I know of at least 5 or 10 different guests who have fallen down or almost fallen down in the parking lot. And then also, I've had guests complain.
About how many guests have complained to you?
I've had 20 different guests in the past couple of months who have come to me complaining again about the parking lot and how dark it is. And yeah,
Did you make any other complaints to Ms. Witter?
I did. On several different occasions, I had come to talk to Miss Witter when she came into the bar a couple of times and told her about, the lighting in the parking lot, how it's dangerous. And I even mentioned the landscape medians and how people could trip on them or try and walk on them.
What was Ms. Witter's response to your complaints?
Logan had said, how is it my fault if guests in the bar can't walk and they trip on something? They should walk better. And then proceeded to call me a dumbass. Logan had always been so condescending towards me.
Did Ms. Witter do anything to address the lighting conditions in the parking lot?
No, not that I had noticed. All she had done was put up a singular sign.
Your Honor, permission to publish Plaintiff's Exhibit 3? Ms. Potter, what is this?
This is the sign Logan had put up.
How many signs like this one were posted in the parking lot?
1. In the entire parking lot.
And what does the sign say?
Sign says, danger, walking through the parking lot should be avoided. Customers should use the sidewalk at all times to reach the area where their vehicle is located.
Did this sign do anything to warn customers of the exposed sprinkler heads?
No, it had not.
Did this sign do anything to warn customers of the poor lighting conditions in the parking lot?
No, it had not.
Did this sign do anything to warn customers why they should be using the sidewalk?
Again, no, it hadn't.
Did this sign do anything to address the concerns that you had regarding the defendant's parking lot?
No. The parking lot was still too dark, and it was like putting a Band-Aid on a bullet hole at best. And it didn't stop my friend Jamie Leery from falling in the parking lot of our sprinkler head and dying.
Thank you, Ms. Potter. No further questions.
Cross-examination.
Your Honor, permission to approach.
These days, we're gonna go back to the old school way of just handing people food.
I hope so, Your Honor, I hope so. Good afternoon, Ms. Potter. Now, Ms. Potter, a moment ago, you said that you were a long life friend of Jamie Leery, correct?
Yes.
And Jamie Leery went to that bar that night, and you served him an old fashioned. What he normally gets, correct?
Yes, just like usual.
And towards the middle of the night, you served him another old fashioned.
Yes, I gave him a second one.
At some point, Jamie Leery, you saw that he came back from the bathroom, correct?
Yes, I had seen him walk back from the restroom.
And you noticed that he stumbled.
Yes, he was a little older, so he stumbled a bit.
Then you saw him stumble again, getting on his chair.
Yes.
And at that moment, you had your own concerns. Because you asked Jamie Leery, are you sure you want another one?
Yes. After a few drinks, I always check in with the clients, see how they're doing.
Now, showing what's already been pre-admitted as Plaintiff's Exhibit 15. Your Honor, may I publish to the jury? Now, Ms. Potter, we're looking here at what is the signs of intoxication, correct? You were shown this a moment ago.
Yes, this is the signs of intoxication training I was given.
Now here it says that you have a responsibility to make sure that your patrons drink responsibly, correct?
Yes, all bartenders do.
And that is your duty to make sure your customers are drinking responsibly.
Yes.
And Your Honor, may I approach the screen to indicate something? Now, Ms. Potter, it says here that what are signs that indicate intoxication, correct?
Yes, those are signs of
And one of
intoxication.
them is poor balance and coordination, correct?
Yes.
Now, stumbling is a poor balance, correct?
I would say so, yes.
And Jamie Leery didn't just stumble once, correct?
Yes, he had stumbled twice.
That's 2 times that you saw poor coordination,
Yes.
yet you didn't stop serving him another old fashioned.
No, I hadn't. He was older and I hadn't seen any other signs of him being intoxicated or overly intoxicated.
Now, I want to show you what's been pre-marked as Plaintiff's Exhibit 3. You're aware that Witter posted a sign, correct?
Yes, the sign.
And that sign was right in front of the ice house, correct?
Yes, it was located right next to a tree next to the ice house.
Showing what's been pre-marked as Starting opposing counsel. Approach the bench. You know Exhibit 32?
Yes.
And Exhibit 32 is a fair and accurate depiction of where the sign was posted out in the parking lot.
Yes.
And Your Honor, at this time, defense moves Exhibit 32 as Defense Exhibit 2.
Any objection?
No objections.
Motion is published to the jury.
You may do so.
Now, Ms. Potter, that yellow circle indicates where that sign was posted out in the parking lot, correct?
Yes.
Now, that night you saw Jamie and Riley Leery walking out, correct?
Yes.
And you walked out with them.
Yes, I walked out to the sidewalk so I could watch them walk away.
Now, showing opposing counsel has been pre-marked as Exhibit 17. Approach the bench. Witness?
Yes.
You know Exhibit 17?
Yes.
You're shown Exhibit 17 when you were given your deposition, correct?
Yes.
And Exhibit 17 shows the path that Jamie and Riley Leery took that night in the park.
Yes, it does.
And Exhibit 17 is a very accurate depiction of Jamie and Riley Leery taking the path of the park.
Yes, it is. And the path of the sidewalk as well.
Yes. Your Honor, at this time, the defense moves Exhibit 17 as into evidence as Defense Exhibit 3.
Objection or vote out?
Just cumulative, it's the same photograph that's already been admitted and it's the same one that was just shown. Just with the,
It goes, does this help you when you're getting the eliciting the testimony from this witness to see this, have her see this photo again?
When was this?
This is a closer up, so I'm gonna overrule the objection. Exhibit 17 is in evidence. And you may publish.
Permission to, yes.
Thumbs up.
Now, Ms. Potter, Your Honor, may I approach the screen?
Absolutely.
Now, Ms. Potter, when you mentioned that you saw Jamie and Riley Leery walk out that night, correct?
Yes.
And you were standing here by Ice House, correct? It was
Yes.
indicated clearly. Now, you mentioned a moment ago also that it was very dark out that night.
Yes.
Now, Jamie and Riley Leery, they fell around towards this area over here, correct?
Yes. Similar.
So, Ms. Potter, there's two travel lanes here, correct? There's 2 lanes of traffic. Right in front of the Ice House, there's two lanes of traffic, 2 streets.
Yes.
And in front of there, there's a space where cars park, correct?
Yes.
And then in front of that, there's another 2 lanes of traffic.
Yes.
And after that, there's 2 more spots where cars park their cars.
Yes, but there wasn't any cars parked that night.
And after that, there's another 2 lanes of traffic.
Yes.
You saw Jamie Leery walk all the way to this part here moments before he fell.
Yes.
Ms. Potter, Riley Leery reached out to you after September 7th, correct?
Yes, he had reached out to me.
And you're aware that bars, if there is any difficulty, any client is intoxicated, that can affect the bar, correct?
Intoxicated or?
If, well, you would agree
Can you
with.
restate that again?
Yeah, I'll restate it again.
Okay.
Sorry, because of the time. If you have a customer that's intoxicated and they get injured, that goes back to the bar, correct?
Yes. Over intoxication and over serving as bartender does come back on me.
And bars, you could be fined if you overserve a customer and they get injured, correct?
objection, relevant to 403.
Did you hear the question?
Will you restate that again? I'm sorry.
The bars could be fined if they find out that one of their customers was injured and they were intoxicated, correct?
Yes, there are repercussions as a bar if we do overserve. Someone is injured.
And a bar could even lose its license if a customer was injured and they were intoxicated.
Yes.
Riley messaged you, telling you not to help with the, Riley Leery messaged you, and she told you that to help you with this case, so you won't be tangled up in this issue, correct?
Yes, Riley had reached out to me and I wanted to help as best as I could after a friend of mine lost his life.
No further questions.
Redirect.
Yes, Your Honor. Your Honor, may I proceed? Ms. Potter, you were asked by Mr. Kalil several questions about Mr. Leery's, your observations of Mr. Leery that night. Based on your observations, did you observe anything that made you stop serving Mr. Leery?
No. I even checked in on him and asked him before he wanted his third drink, and he seemed completely fine. He had stumbled a little bit, but again, he was an older man, so it was common for someone his age to stumble. But no other signs of intoxication were present that I had checked for.
And what does your training require you to do if you observe a customer is intoxicated?
If I observe that a customer is intoxicated, immediately I stop serving them. And because obviously as a bartender, you can lose your license, it's taken very seriously.
You were also asked about the sign that was posted outside the restaurant. Did that sign on the evening of September 7th, 2024, prevent people from getting hurt?
No. Sign had done nothing to prevent people from getting hurt. It didn't explain to them why they should stop, it didn't tell them why they should stop, and it did nothing for Riley Leery or Jamie Leery.
Thank you, Ms. Potter. I have no further questions.
Thank you. You may step down. Next witness, please.
Your Honor, plaintiff calls Cameron McPhee to the stand.
All right, please approach the witness stand and remain standing, and the court will switch in. Please raise your right hand. You solemnly swear or affirm the testimony you will give in this case will be the truth.
Sorry.
You receive it. Please state your name for the record and spell your last name.
Cameron McPhee, McPhee,
And spell Cameron for me.
Camer.
You may inquire.
Thank
Do
you,
you
Your
need the
Honor.
podium or you?
No, Your Honor.
Okay,
Thank you.
you may proceed.
Good evening. Will you please introduce yourself to the members of the jury?
Good evening, my name is Cameron McPhee.
What do you do for a living, Mr. McPhee?
I am a landscaper as well as an owner and operator of a business.
How long have you been a landscaper for?
I've been a landscaper for about 20 years or so.
Did you go to college?
Yes, I did.
Where?
I went to Hanover A&M University. I got my bachelor's in horticulture and my master's in architectural design.
Do you have any certificates or licenses?
Yes, I do. I am a licensed architectural designer and I'm certified in irrigation design as well.
As a landscaper, what do you do?
As a landscaper, I do several different things. Primarily, I design landscaping for residential commercial buildings. I also look at parking lots and design the landscaping for parking lots. In addition to that, the specific installation of shrubbery, trees, bushes, and any irrigation that would be involved in like making sure the landscaping looks good.
As owner of your own landscaping company, what types of projects do you work on?
Well, for example, I was working with a commercial and some also residential buildings, designing some of their landscaping, including some public parks and retail plazas. I've looked at the parking lots as well for, same thing, looking at their ingress and egress routes for some retail plazas as well. In addition to that, I've also oversaw several different compliance reviews to make sure that the landscaping and the structures around it are in line with the city ordinances.
About how many projects have you worked on involving the designing of parking lots?
I would say about 100, give or take.
What brings you here today, Mr. McPhee?
I was hired by Riley Leery to deliver an extra report.
In regards to what?
I was supposed to give a expert report in terms of the parking lot in which Mr. Leery fell and passed.
Were you able to reach a conclusion regarding the parking lot where Jamie Leery passed?
Yes, I was.
Are you being paid to be here today?
Yes, ma'am.
How much?
To be here today, I am being paid $750 an hour to testify, and I was paid $500 an hour in the building of my report.
Are your opinions and conclusions based on a reasonable degree of professional certainty?
Yes, ma'am.
Are your opinions and conclusions based on your experience, skill, and knowledge?
Yes, ma'am.
What materials did you review to reach a conclusion in today's case?
In addition to the materials that I used, investigated and used to build my report, I also looked at the exhibits for this case as well as the depositions of Riley Leery, Avery Potter, and Logan Witter.
Are these materials sufficient for you to reach a conclusion in this case?
Yes, ma'am.
Did you go out to the parking lot to investigate?
Yes, ma'am.
What were you looking for during your investigation?
I was looking for three things primarily. I was looking for the state of the lighting fixtures in the area, in the parking lot. I was looking at whether or not the sprinkler head of the subject landscape medium was dangerous, and looking at the ingress and egress routes of said parking lot.
Did you take measurements in this case?
Yes, ma'am.
Did you apply local city ordinances?
Yes, ma'am.
Are these materials generally accepted in the landscaping industry?
Yes, ma'am.
Is this methodology generally accepted in the landscaping industry?
Yes, ma'am.
I want to talk to you about the parking lot that you went out to investigate. During your investigation, did you learn who owns this parking lot?
Yes, ma'am.
And who owns this parking lot?
That would be Witter Development.
Who is Witter Development?
Witter Development is a real estate development company. They own and operate around 25 real estate development properties in and around the Wilmington area.
Who owns Witter Development?
That would be Logan Witter.
Are you familiar with either Witter Development or Logan Witter?
Yes, ma'am.
How?
We've done some business in the past.
Does your history with either one of them affect the opinions you're giving in today's case?
No, ma'am.
I want to talk to you about the findings of your report. When did you go out to the parking lot to investigate?
I went the evening of September 14th, 2024.
How long after Jamie Leery's fall was this?
That was about a week or so from the incident.
And what were the findings in your report?
So, like I said, I had pretty much three things I was looking for. The first thing to the lighting. The lighting was insufficient and
Your Honor, I'm gonna object to improper expert opinion.
At this time, members of the jury, expert witnesses are like any other witness that comes in to testify, but the law allows one exception. An expert is only an expert witness on any subject matter if you believe that they are. But if you don't, like any other witness, you may believe all or any part of an expert witness's testimony. So I am going to allow this witness to give an opinion. I'll note your objection, but it's overruled. You may proceed.
If you may continue, what were the findings of your report?
As I was saying, my first finding was that the lighting in the structures for the parking lot were insufficient and more times than not out of compliance with local city ordinances, to the point of the sprinkler head of the subject landscape medium. It was a dangerous, and to the third point of the ingress and egress routes, they didn't make much sense.
Okay, let's talk about these findings one by one. First, starting off with the lighting. What was your opinion regarding the lighting?
Well, the lighting, like I said, was not sufficient and therefore dangerous for pedestrians.
Which city ordinance did you apply in this parking lot?
The Wilmington City ordinances.
What does this ordinance say regarding lighting in parking lots?
The ordinance pretty much lays out the minimum and maximum requirements for lighting in a parking lot.
And what did you find when you applied this ordinance?
I found that there were areas of the parking lot that were insufficient in terms of, what is to be, at least for the minimum of the ordinances.
How did you find this?
I used a light measurement device that measures the lighting on the surface of the ground.
Have you ever used this tool before?
Yes, I have.
Is it important for parking lots to meet the standards under city ordinances?
It's very important now.
Why?
Because aside from just being in compliance with ordinances, if the lighting isn't sufficient, then it becomes very dangerous for pedestrians that may be walking in the parking lot at night.
When you're installing lighting in parking lots, what do you normally aim for?
Well, the minimum is 0.5 foot candles. Now, it's kind of hard to explain like what that means, but when I'm designing lighting fixtures and maintaining them, I aim for the maximum, which is closer to 5 foot candles.
During your investigations, did you see any areas where the lighting was missing?
Yes, I did.
Approaching opposing counsel with what has been previously marked as Exhibit 40. Permission to approach the bench.
You may.
Permission to approach the witness.
You may.
Do you know what this is?
Yes, ma'am.
What is this?
That is a picture of one of the lighting fixtures in the subject parking lot,
And how do you know that this is a picture of that?
because I took the picture.
Is this a fair and accurate depiction of a photograph you took in the subject parking lot?
Yes, ma'am.
Your Honor, at this point, we offer what has been previously marked as Exhibit 40 into evidence as Plaintiff's 15.
Any objection?
No objection, Your Honor.
Permission to publish?
You may.
Mr. McPhee, what is your opinion about the lighting in this photograph?
As I said before, the lighting is insufficient for a pedestrian in the parking lot and would serve as a dangerous, scenario for a pedestrian.
Why is it dangerous?
Well, it's, if you're a pedestrian in a parking lot and there's insufficient lighting like this, you could be a hazard to tripping over parking bumpers, landscape mediums, or, anything that's in the parking lot. It's just hard to see.
During your investigation, did you see a sign?
Yes, I did.
Where was the sign located?
The sign was located right outside the front of the ice house.
What is your opinion regarding the wording of the sign?
Well, I wasn't particularly asked to consider the sign or the wording of the sign in my report, but I really think the language was fine. However, it's really hard to say whether or not Mr. Leery saw the sign and read the sign when he was leaving the establishment.
Let's talk about your second finding, the exposed sprinkler head. What type of sprinkler head did Jamie Leery trip over?
The sprinkler head is what's known as a retractable or pop-up sprinkler head.
Now showing opposing counsel what's been previously marked as Exhibit 60. Permission to approach the bench.
You may.
Permission to approach the bench.
You may.
Do you know what this is?
Yes, ma'am.
What is this?
This is a diagram of a pop-up or retractable sprinkler head.
And how do you know what this is?
Because I've worked with them pretty much my entire time doing landscaping.
It's a fair and accurate depiction of a diagram of a retractable sprinkler head.
Yes, ma'am.
Your Honor, at this point, we offer what's been previously marked as Exhibit 60 into evidence as Plaintiff 16.
Objection or vote aye?
No objection, Your Honor.
Permission to publish?
You may.
Mr. McPhee, will you explain to the members of the jury what a retractable or pop-up sprinkler head is?
Yes, ma'am. So a retractable or pop-up sprinkler head comprises of two parts. There is the actual sprinkler head. It's about 3 to 4 inches in height. It's black, usually like that. And there's the second part, which is the base, which is a little bit wider than the sprinkler. And basically those two work in tandem. So when the sprinkler is in operation, it pops up, it sprinkles the water. And when it's not in operation, then it retracts back down to the base, pretty much flush with the ground.
Is it normal for a retractable sprinkler head to remain exposed when it is not turned on?
No, ma'am.
What does it mean if this does happen?
That usually means that something is broken, one of the two parts are broken, or there is an issue, in how it's manufactured. It needs to be fixed.
Are you familiar with the Wilmington City Ordinance that talks about ground surface hazards?
Yes, ma'am.
Did you apply that ordinance in today's case?
Yes, ma'am.
What does that ordinance say?
The ordinance essentially says that any obstruction that's coming out from the ground in a place where there's the public, if it is an obstruction, and it must be removed by the person in charge of maintaining the area.
Would a retractable sprinkler head that remains exposed fall under this ordinance?
Yes, ma'am.
What must happen then?
Then the person that's in charge of maintaining the area must take steps to either fix the obstruction or get rid of it.
Were these sprinklers removed during your investigation?
No, ma'am.
During Jamie Leery's fall, was or were these sprinklers in use?
Yes, ma'am. Oh, yeah, I'm sorry. Excuse me, they weren't used, my bad.
Is there any purpose for retractable sprinkler heads in an area with no grass?
No,
In your opinion, was there any purpose for these sprinklers during your investigation?
not at all.
Now retrieving what has been previously marked as Plaintiff Exhibit 4, permission to publish. May my witness step down to demonstrate for the members of the jury?
Absolutely. Please watch your step as you go down.
Mr. McPhee, will you show the members of the jury where the sprinkler head was located?
Yeah, of course. Sorry, it's right here. Kind of hard to see there, but if you guys can see right there, that's the sprinkler head right there, about, like I said, 3 to 4 inches in height.
You may sit down. Thank you. During your investigation, was this sprinkler head easy to see?
No, ma'am.
Why not?
Well, as I said, it kind of blends in into the surrounding area, and it's small enough to where you really can't see it, especially when it's in a not well lit area. You kind of need to get on the ground to see it.
Now let's talk about your last finding, the design of the parking lot. What was your opinion regarding the design of the parking lot?
Well, like I said before, the design's nonsensical and just doesn't really make sense.
Why not?
Because it's not practical for use, and in the way it's designed currently, doesn't really make sense for someone that's parking in a parking lot, parking their car, walk all the way to the designated sidewalk, which depending on where they park could be really close or really far, and then walk all the way around the parking lot to the entrance of the ice house.
Were customers taking another route back to their cars?
Yes, ma'am.
How?
They would just walk through the parking lot.
During your investigation, did you learn of customers taking this path?
Yes, ma'am.
How did you learn of this?
I learned of this through some of the exhibits, including emails between Avery Potter and Logan Witter.
Could have Witter Development designed their parking lot differently?
Yes, they could have.
How?
Well, I use this a lot of times when I'm designing ingress and egress routes, building sidewalks that are integrated in the parking lot so people can go park their cars and walk through the parking lot safely.
Thank you. No further questions.
Cross-examination.
Just a moment, Your Honor.
Yeah, can you just... Your Honor, if I may approach?
Good evening, Mr. McPhee.
Good evening.
You're here to give an expert opinion, correct?
Yes, ma'am.
And an expert should be unbiased, right? And an expert should be as accurate as possible,
Yes,
right?
ma'am.
That's what you're here to do.
Yes, ma'am.
You're here to be unbiased and accurate as you possibly can,
Yes,
right?
ma'am.
So, Mr. McPhee, you know Witter Development, right?
Yes, ma'am.
And you know Logan Witter too, right?
As I said before, yes, ma'am.
Yes, and you sued them in the past,
Yes, I have.
right? And you have bad blood with Witter Development, correct?
No, ma'am.
Well, you're here testifying against them today.
I was hired to give an expert opinion, and that's what I'm doing.
And you're here testifying against them today despite the fact that you sued them in the past, right?
Yes, ma'am. I don't see how a prior legal incident has to coincide with an expert opinion that's based on facts.
Mr. McPhee, you also threatened Logan Witter, right?
See, I don't think that's entirely accurate, because if in this scenario, I remember we had after the lawsuit, there was a disagreement, basically based upon the fact that Logan Witter and Witter Development did not pay what they were invoiced to pay. They insulted my business and my work. I mean, I think if someone insulted your work, counselor, you'd also be pretty upset.
That's not the question that I asked you, Mr. McPhee. I asked you if you threatened Logan Witter.
I wouldn't call it threatened, but
So you didn't tell Logan Witter that he better hope that you don't catch him in an alley?
yes, I did, ma'am.
So you did threaten Logan Witter.
In that scenario, yes, ma'am.
And you also called Logan Witter an asshole, right?
Like I said, if someone was insulting your business.
Please answer the question, yes or no, did you
Yes,
say
ma'am.
that? Thank you.
Thank you, Your Honor. Additionally, you didn't refer this case out, correct, Mr. McPhee?
No, ma'am.
You didn't refer this case out to another landscaping company?
No, ma'am.
You didn't refer this case out to a colleague?
No, ma'am.
You personally accepted to work on this case, right, Mr. McPhee?
Yes, ma'am.
Despite your history with Witter Development.
The Leerys are church friends of mine, and when I heard about what happened, I reached out and offered my opinion, my 20 years of expert, and the lawyers thought that my opinions were great.
Yes, Mr. McPhee, you reached out to them, right?
Yes, I did.
They didn't come to you.
Yes, ma'am.
You offered yourself.
Yes, ma'am.
Okay. So, Mr. McPhee, you gave some opinions in this case, correct?
That's correct.
Let's talk about the sprinkler system. You talked about the sprinkler system, right?
Yes, ma'am.
And you cited to an ordinance regarding the sprinkler system, right?
That is correct, ma'am.
That was section 1331B2, right?
That is correct.
And that section talks generally about obstructions, projections, and things of that nature, right?
That is correct, ma'am.
And you were of the opinion that that section required that the sprinkler system be removed, right?
And the language, although a little vague, does speak to obstructions coming out from the ground, yes, ma'am.
So you were of the opinion that that ordinance required the sprinkler head system be removed?
Like I just said, if there's an obstruction coming out from the ground, then yes.
Okay, but you're aware that the subject sprinkler system is retractable, right?
Yes, ma'am.
But you're also aware that non-retractable sprinkler systems exist as well, right, Mr. McPhee?
I'm aware, yes, ma'am.
So does this ordinance account for non-retractable sprinkler systems?
Well, I didn't write the language.
But you cited to it, right, Mr.
Objection,
McPhee?
Your Honor, relevance, as we are here today for a retractable pop-up sprinkler head.
You may answer.
Like I said, what
You
the
cited to the ordinance, is that correct?
Yes, ma'am.
Thank you, Your Honor. So you cited to that ordinance, and that ordinance says nothing of a sprinkler head specifically, right? Sprinkler system specifically.
No, ma'am.
It also says nothing regarding the height of what would be considered an obstruction, right?
No, it does not.
So you'd agree that the ordinance is vague, right, Mr. McPhee?
Yes, ma'am.
Right. You also talked about the lighting post in the parking lot, correct, Mr. McPhee?
Yes, ma'am.
Your Honor, at this time, I'm going to be retrieving what has been pre-marked as Plaintiff's Exhibit. Yes. Excuse me, I'm just going to be retrieving what has been pre-marked as Exhibit 39. Karen McPhee, can you take a look at, Exhibit 40, can you take a look at that?
Yes, ma'am.
You know that photo, right?
Yes, ma'am.
And you know that photo because you took that photo,
Yes,
right?
ma'am.
And that photo depicts both light bulbs out, correct?
Yes, ma'am.
You also took other photos at the parking lot that day, right?
Yes, ma'am.
Your Honor, at this time, I'm going to be moving. I see that my time is out, Your Honor. Wait, may I
Why don't
have?
we just take a short bathroom break, recess? Members of the jury, don't talk about this case while we're on break or recess among yourselves. Just go to the bathroom and then come back, 5 minutes. 5 minutes, everybody.
Thank you, Your Honor.
All right, ladies and gentlemen, you may be seated. The record will reflect the presence of all the jurors, the litigants are here. Mr. McPhee is still on the witness stand. You may continue with your inquiry.
Thank you, Your Honor. Okay, so before our break, we were talking about that parking lot lamp. And you also took additional photos, correct?
Yes, ma'am.
All right, Your Honor, at this time, I'm going to be moving what has been pre-marked as Exhibit 39 into evidence showing opposing counsel. Permission to approach, Your Honor?
You may.
Permission to approach the witness?
You may, and you may publish to the jury afterwards.
All right, thank you, Your Honor. So, Mr. McPhee, you know what this is, right?
Yes, ma'am.
And you know what this is because you took this photo, right?
Yes, ma'am.
And this is a true and accurate copy of the photo that you took on September 14th, 2024,
That is correct, ma'am.
right? Oh, sorry, Your Honor, let me go ahead and give that to you. Mr. McPhee, this is another photo you took of in the parking lot, correct?
Yes, ma'am.
And that photo depicts both of the lights on, correct?
That is correct, ma'am.
And you weren't shown this photo on your direct, right?
That is correct, ma'am.
And just real quick, let's go back to this other photo, Exhibit 40. This was taken 7 days after the incident, correct?
That is correct, ma'am.
So you can't tell us that these lights were out on the date of the incident, right?
Can you please clarify?
Since these photos were taken 7 days after the incident, you follow?
Yes, sir.
You cannot say that these lights were out on the date of the incident.
Well, that light's out, but the other one, yes, that one was not.
I'm asking about the date of the incident, Mr. McPhee.
Oh, I understand, then it's hard to say no.
You can't tell us that the light was out on the date of the incident, correct, Mr. McPhee?
I can't tell you that, no.
Okay. Now, excuse me. Now, I want to talk a little bit about the X-Tech light meter that you used in this case. You want to be as accurate as possible, right?
Yes, ma'am.
You want to be as diligent as possible?
Yes, ma'am.
And if you're using tools, you want those tools to be as accurate as possible, right?
Yes, ma'am.
And you used a light meter during your inspection,
Yes, I did, ma'am.
and sitting here today, you did not know before you were deposed that it is recommended that light meter be calibrated, correct?
That is correct.
Your Honor, at this time, I'm going to be publishing or moving into evidence what has been pre-marked as Exhibit 65, showing opposing counsel. Permission to approach? Cameron McPhee, you know what this is, right?
Yes, ma'am.
And you know what this is because you were shown it during your deposition, correct?
That's correct, ma'am.
And this is the factory recommendation for the calibration of your light meter, right?
It is recommendation.
All right, Mr. McPhee. I know it's a little bit hard to read, but if you get up, can you read that second sentence? Or matter of fact, I will read it for you. It says, an annual factory calibration is recommended. That's right, Mr. McPhee?
That's what you said, ma'am, yes.
Yes, and you failed to familiarize yourself with that recommendation before you were deposed, right?
Yes, ma'am.
You weren't diligent in making sure that you knew about that recommendation before you were deposed, right?
That is correct.
So the entire 5 years that you owned that light meter, you didn't have it calibrated once, right?
Although it was recommended, that I did not have.
Yes, you didn't have it calibrated after the first year? You didn't have it calibrated after the second year?
The second, third, fourth, or fifth.
You didn't have it calibrated after the third year?
No, ma'am.
You didn't have it calibrated after the fourth year?
Objection, Your Honor, asked and answered.
And you didn't have it calibrated on that 5th year of owning it, right?
No, ma'am.
So any measurements you offer are not the most accurate measurements possible, right?
I would say that's inaccurate to say. I've used this before in the last 5 years, and my 20+ years of experience in education, no measurement I took was out of line with what my experience has shown.
Mr. McPhee, do your eyes measure foot candles?
No, but they can see when there's pitch black parts of the parking lot.
And one last thing, Mr. McPhee, were you shown by the plaintiff any of the measurements you took in this case?
Can you re-ask
From the light meter, did the plaintiff show you any of the measurements you took in this case?
Well, they're my measurements, I've seen them before.
Did the plaintiff show you any of the measurements you took in this case?
Not specifically, no.
No further questions.
Redirect?
Yes, Your Honor.
Mr. McPhee, you were just asked about the light meter tool you used in conducting your investigation.
Yes, ma'am.
Is it required for a light meter tool to be calibrated?
No, ma'am.
Has it ever given you inconsistent results?
No, ma'am.
Not in your past 5 years of using this tool?
That is correct, ma'am.
Does your opinion change regarding the lighting in this parking lot?
Not at all, ma'am.
Now, you were also asked about your prior history with Logan Witter.
That's correct, ma'am.
Would you work with Witter Development or Logan Witter again?
No, I wouldn't.
Why not?
Well, I just really wouldn't work with a business that seems to try to pinch pennies any and everywhere they can. Especially, you know, like I said, the disagreement between me and Witter Development was based upon not being paid.
Are you here to follow up on that threat you made years ago in that lawsuit?
Not at all.
Are you here today seeking revenge against the defendant?
Not at all.
Thank you. No further questions? May my witness be excused?
Well, let me ask, the new area, any redirect? Alright,
Recross.
recross, I'm sorry.
Recross?
Just in this limited area. On cross, on the redirect.
Yes, Your Honor. Mr. McPhee, you were just asked on redirect regarding your history with Witter Development
That's correct.
and whether or not you would work with them again.
Yes, ma'am.
And you explained that you wouldn't because you were unpaid, right?
Well, I was initially unpaid after the case that was settled, which we can't talk about all the terms of the settlement, but yes, I initially sued Witter Development to get what I was properly earned.
Yes, you did receive payment from Witter Development,
After the
correct?
settlement, yes.
Excuse me?
Let me clarify. The settlement came after, but I was paid partially. I believe Mr. Witter said that he didn't want to pay Rolls-Royce prices for a Toyota work, which I believe with my 20 years of experience, it insults my business, but that's a side thing.
All right, no further questions, Your Honor.
Thank you. Now, Mr. McPhee, you may step forward. May I call your next witness?
Your Honor, plaintiff for us.
Members of the jury, the plaintiff has rested their case in your presence. Counsel, if we can defer on motions, that way I can not rush through. So is the defense prepared to go forward with their case?
Your Honor, at this time, the defense is going to move for a directed verdict in this case.
Okay, I'll reserve on that and hear arguments, but I just want to get the witnesses on the witness stand before I make any rulings, so. You have any witnesses that you can call before we go into motions?
Yes, Your Honor. The defense will now call Logan Witter to the stand.
And the record will reflect that the motion for directed verdict is properly preserved and reserved for further argument before this court. All right, Ms. Logan, Ms. Witter, I'm sorry, Ms. Witter. Ms. Witter, please remain standing for the record. You solemnly swear or affirm the testimony you give the court will be the truth.
I do.
You may be seated. If you state your name for the record and then spell your last name.
Hello, my name is Logan Witter, Witter.
You may inquire.
Good evening, Mrs. Witter. Can you please tell this jury a little bit about your background?
I'm a Wilmington native, I'm married, and I have 3 children.
Okay, and did you go to any college or university?
Yes, I did, I went to Wilmington State.
And what did you study while at Wilmington State?
I studied business, where I earned my business degree, and I also received my MBA.
And are you currently working?
Yes,
Where do you work at?
I am the owner of Witter Development LLC.
And what is Witter Development?
We are a real estate development company.
Mrs. Witter, why are you here today?
I'm here to testify on behalf of my company.
Okay, Mrs. Witter, let's talk a little bit about your company. What is Witter Development's business model?
Our business model is to purchase distressed properties and to make them into something more valuable.
And what do you generally turn these properties into once you buy them?
It could be things such as like apartment complexes or housing subdivisions. We also do commercial property, so things like business offices, medical places, and shopping plazas.
And do you generally hang on to the properties once you buy them, or do you sell them off?
Sometimes we do maintain ownership, but we do sometimes sell them for profit.
Okay, and when you choose to maintain ownership, what is your role as a landlord?
My role can vary between collecting rent from tenants, fostering good business relationships with my tenants, maintaining the common areas, and negotiating leases.
Okay, let's talk a little bit about the history of the property. When was the project completed for the subject shopping center, the one we're talking about today?
In 2005.
And are you familiar with the Ice House?
Yes,
How are you familiar with the Ice House?
they are a tenant of mine
And how long has the Ice House been a tenant of yours?
for 20 years.
And have you visited the Ice House throughout the years?
Yes, I have.
And what about the shopping center in general? Have you visited them throughout the years?
Yes, frequently.
Okay, let's talk about some of the complaints that might have arisen throughout the years. Did you ever receive any complaints regarding the lighting in the parking lot?
Yes, I have.
All right, Your Honor, at this time, I'm going to be retrieving what has been pre-marked as Exhibit 30. Mrs. Witter, what did you do after receiving this complaint from Avery Potter?
I went out with my landscaping subcontractor to go and check the lights in the parking lot.
Okay, and about what time of night did you guys go?
Around 10 p.m.
And what was the name of that landscaping subcontractor that you brought with you?
Casey McCain's from McCone's Landscaping.
And did that subcontractor use a light meter during the
Yes.
inspection?
Yes, they did.
Okay. And did you receive any kind of communication from the subcontractor after your inspection?
Yes.
Okay. Your Honor, at this time, I am going to be moving what has been pre-marked as Exhibit 67 into evidence. Permission to, or showing opposing counsel, my bad.
Yes, Your Honor, objection. As to this email is hearsay under Federal Rules of Evidence 801 and inadmissible under Federal Rules of Evidence 802.
Your Honor, if I may respond.
I'm listening.
So this exhibit is hearsay, however, there is an exception for it. The exception is then present state or then present sense impression, 803.1, and it is not being offered to show that the lighting was in compliance. Rather, it's being offered to show that Logan Witter, how he perceived that moment. He was there with the subcontractor, and it is based on his perception and his reliance on what he saw, and additionally, what the subcontractor saw that day.
Your Honor, if I may respond.
I'm listening.
This email was sent on July 23rd, 2022, and in Logan Witter's deposition, he states that he went out to the parking lot a couple of days after receiving Avery Potter's email, which is Exhibit 67, and therefore it cannot be proven that this email was made while the subcontractor was inspecting the lighting or immediately after. In fact, the email in Exhibit 67 says, "Just wanted to follow up in writing about our recent inspection." Therefore, it is not a present sense impression because this statement does not describe or explain an event or condition made while or immediately during the declarant's perceivance of this event.
Your Honor, is that not the correct?
Various emails that have been introduced. I'll note the plaintiff's objection, but the exhibit is going to be received in evidence and let the witness read it into the record.
Thank you, Your Honor. All right, Mrs. Witter. Is this the email that you received from Casey McCain?
Yes.
Okay, and what did you learn from that email that you received from Casey McCain and your inspection of the
Just
park?
have her read it into the record, it is self-explanatory.
All right,
Please read the exhibit into evidence, please.
yes.
I learned that the parking lot complies with the City of Wilmington ordinance.
Go ahead and read the whole.
Read the entire exhibit.
Okay.
Just wanted to start with that line.
Hey Logan, just wanted to follow up in writing about our recent inspection of the parking lot at the shopping center. As you know, since you were there with me, we walked around the parking lot, observed all of the lighting fixtures in the parking lot, and checked the lighting in various areas using a light meter. Based on our inspection, the lighting in that parking lot complies with City of Wilmington ordinances that require a minimum of 0.5 FC measured at ground level. Of course, if you wanted to, we could always add more lighting in the parking lot, but it's not needed at this point to come into compliance with city codes. Thanks for thinking of us and let me know if you need anything else. Casey McCain.
All right. Thank you, Mrs. Witter. So, following that initial complaint that you received from Avery Potter, did you receive any subsequent complaints?
Yes, from Avery Potter.
Okay, Your Honor, at this time, I'm going to be retrieving what has been pre-marked as Exhibit 31. Mrs. Witter, what did you do following receipt of this complaint?
After I received that email, I did not go back to check out the lighting, but I did put a sign up.
Okay, and Your Honor, at this time, I'm going to be retrieving what has been pre-marked as Exhibit 11. Is this the sign that you put up, Mrs. Witter?
Yes,
And where did you have that sign put up?
right outside of the ice house.
And why did you have that sign put up outside of the ice house?
Well, there were customers coming out disorderly out of the ice house.
And what does that sign say generally?
Danger and that the customer should take the sidewalk.
Okay, and let's talk a little bit about the landscape medians in your parking lot. Who designed the landscape median in the parking lot?
Witter Development and the landscaping subcontractor.
Okay, and did the design for the landscape median change over time?
Yes,
How did it change?
it changed from grass to mulch.
And did that median include a sprinkler system?
Yes,
And did that sprinkler system remain even after the transition from grass to mulch?
yes.
Can you explain to this jury why that sprinkler system remained?
Well, it's retractable, so it wouldn't pose a danger.
And were customers intended to walk across the median?
Not at all.
Okay. Mrs. Witter, let's talk a little bit about the sprinkler head in this case. So prior to September 7th, 2024, were you aware of this sprinkler head?
No,
Did any tenants tell you about this sprinkler head?
no,
Did Avery Potter ever tell you about this sprinkler head?
no,
Did anybody ever tell you about the existence of this sprinkler head?
no.
All right. Finally, we're almost done. I'm just gonna ask you a couple more questions, but this is regarding the ice house. Did you have concerns regarding the conduct of customers leaving the ice house?
Yes.
Why did you have those concerns?
Well, like I said previously, the customers would come out disorderly and they would stumble around and also piss on trees.
Did you discuss these concerns with Avery Potter?
Yes,
And from your knowledge of this case, had Jamie Leery been drinking on the day of September 7th, 2024?
yes,
Had he been drinking at the ice house?
yes.
And where had Jamie Leery been immediately before tripping and falling in that parking lot?
The ice house.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. I want to talk to you about Witter Development. You own Witter Development?
Yes,
And as owner, you oversee everything in the company.
Correct.
Witter Development is a real estate development company.
Yes.
Witter Development also serves as a landlord,
Yes.
including commercial tenants.
Yes.
As landlord, you maintain certain areas of a property.
Yes.
Those areas include common areas.
Yes.
If talking about a shopping center as your tenant, those common areas include the parking lot and sidewalk.
Yes.
So Witter Development is responsible for maintaining the safety of these common areas.
Correct.
I want to talk to you about the parking lot located right outside of the ice house. Witter Development built this parking lot.
Yes.
Witter Development is responsible for maintaining the parking lot and sidewalk located outside of the ice house.
Yes.
As landlord, you receive complaints from tenants.
Yes, I have from Avery Potter.
Yes, let's talk about these complaints that you've received from Avery Potter. Your Honor, permission to approach to retrieve exhibits? Permission to approach the witness? These emails were sent to you from Avery Potter.
Yes.
Avery Potter is a tenant of yours.
Correct, for 20 years.
In both of these emails, Avery Potter complained about the lighting.
Yes.
In both of these emails, Avery Potter asked you to do something about the lighting.
Yes.
And in both of these emails, Avery Potter told you about customers complaining,
Yes.
customers falling,
Yes.
and customers tripping.
Yes.
Now let's talk about the first email you received. This email was sent in 2022.
Yes.
And after you received this email, you went out to the parking lot with your subcontractor.
Correct.
Your subcontractor checked the lights,
Yes.
but with the light meter tool.
Yes.
You don't know anything about this light meter tool that your subcontractor used?
No, that's why I brought out the subcontractor.
You don't know whether this tool was calibrated?
No.
And then afterwards, your subcontractor confirmed that the lighting was in compliance.
Yes.
Let's talk about the second email. This was sent 2 years after you checked the lighting,
Correct.
in 2024.
Yes.
But after you received this email, you didn't go check the lighting.
No, I put up a sign.
A sign that didn't mention the lighting conditions,
No.
didn't mention the exposed sprinkler heads.
No.
The sign wasn't illuminated.
No.
Only one sign in your entire parking lot.
Correct.
You didn't send your subcontractor to go check the lighting after the second email, 2 years after.
No.
You didn't send any employees.
No.
And even if, and this sign told customers to stay on the sidewalk.
Yes.
Even if customers were to use this sidewalk, at one point they would have to enter the parking lot to get to their cars.
Correct.
I want to talk to you about the exposed sprinkler head. Witter Development designed the landscaping for this parking lot,
Yes.
and originally there were sprinklers installed on your landscape medians
Correct.
because the original plan was to have grass on these landscape medians.
Correct.
But since it was too expensive to maintain this grass, you switched over to mulch.
Yes.
And this change took place from grass to mulch 10 years ago.
Yes.
But you didn't remove those sprinklers
No.
because it cost too much money.
Yes, but that's not the only reason.
The other reason is because since they were retractable, they were supposed to retract into the ground, correct?
Correct.
Approaching opposing counsel, what has been previously marked as Exhibit 68. Permission to approach. Permission to approach the witness. You know what this is, right?
Yes.
This is an email between you and your chief financial officer,
Correct.
and this is a fair and accurate depiction of this email.
Yes.
Your Honor, at this point, plaintiff moves to offer what has been previously marked as Exhibit 68 into evidence as Plaintiff 17.
Objection?
No objections, Your Honor.
You may publish.
Thank you, Your Honor. This email was sent and received back in 2014.
Yes.
This email was from your CFO.
Correct.
Your CFO gave you a quote on how much it would cost to remove these sprinkler heads.
Yes.
it would have cost $4,000 to $5,000 back in 2014 to remove these sprinkler heads.
Correct.
That cost wouldn't have bankrupted Witter Development,
No.
but you chose not to remove these sprinkler heads.
Correct.
And you knew that a couple of these sprinkler heads were malfunctioning.
Yes, but not this one.
Yes, but a few of them.
Correct.
In fact, your exact words in that top email was, "It's just a couple of sprinkler heads sticking up out of the ground, right?"
Correct.
And you knew, there was no grass in the area when these sprinklers were still there?
No.
And you knew that customers were walking around or near the landscape medians where these exposed sprinkler heads were located?
Correct.
So for 10 years, you knew that there was exposed sprinkler heads in your landscape medians.
Correct.
And all you did was put up a sign.
Correct.
You didn't do anything else for 10 years in regards to these sprinkler heads.
Correct.
No further questions, Your Honor.
Redirect.
Okay. Mrs. Witter, a moment ago during your cross, you were asked about the exposed sprinkler heads. And since that's, can you actually read that up? Since we were talking about that, what else did you say with respect to the sprinkler system in that email?
That I made sure to bring out the landscaping guys to the parking lot if there's issues.
And did you have maintenance done in the parking lot?
Yes,
How often did you have maintenance done in the parking lot?
on a quarterly basis.
And during any of those routine maintenance checks, were you ever made aware of any issues with the sprinkler system?
No, not at all.
Did the city ever give you any violations about your parking lot?
No,
Did you ever receive any warnings from the city regarding your parking lot?
not at all.
Did you ever receive any violations from the city regarding your parking lot?
Not at all.
Right. No further questions, Your Honor.
Mrs. Witter, you may step down. Next witness?
Yes, Your Honor. The defense calls Dylan Lindell.
Your Honor, prior to calling the next witness, we would like to perform a voir dire of this witness pursuant to Your Honor's ruling on the motion in limine.
Well, I think if you make the proper objections, we don't have to go dire. You want to give the court a proffer to support your motion to go dire this witness?
Your Honor, just we would stand on our previous grounds that were argued during motion in limine, that this witness under 702 doesn't have the sufficient facts, data, or evidence to properly testify as to the retrograde analysis or Mr. Leary's alleged
All
impairment.
it takes is a report. If they can use learned treatises, they can use a paper bag to form their opinion. It's up to the jury to determine whether or not they're an expert in the opinion that they give. So I'll stand by the jury instruction.
Yes, Your Honor.
Your Honor, may I approach to...
You may. Some of the defense exhibits.
Your Honor, may I approach to put a label on the...
Absolutely. Why don't we come back to council table and then bring it up, I'm gonna get this witness under oath. Good evening, sir.
Good
You
evening.
solemnly swear or affirm that the testimony you're about to give will be the truth.
Yes, I do.
You may be seated. Please state your full name and spell your last name for the record.
Yeah, my name is Dylan Lindell, Lindell.
Can you spell, Dylan,
Yeah.
as a taking notes?
Dylan, Dylan.
You remain quiet.
Your Honor, may I approach?
Yes.
Good afternoon.
Good afternoon.
Can you please take a moment and introduce yourself to the jury?
I'm Dylan Lindell.
Now, Mr. Lindell, why are you here today?
Here to give my opinions on the accident that occurred.
Before we talk about your opinions, I want to know what qualifies you to give an opinion.
Absolutely.
Can you tell us about your educational background?
Yeah, so I got my bachelor's degree in psychology from the University of Wisconsin. I went on and got my master's degree in human behavior, and I got my PhD in human factors, and cognition.
Now, what is the human factors and cognition?
Yeah, so human factors is basically the study of how a human would interact with a space, how someone would, cognitively interact with, could be a building, a parking lot, a movie theater, you name it, and how their behavior, which could be impaired for a various amount of reasons, would impact that.
Now, after you graduated with that, what did you do?
So I went on to work as a human research and human factor scientist, and I conducted a lot of research in the field, a lot of work with, civil work, premises liability work, and then I went on and worked for the government in a research role in human factor analysis, where I conducted various research on different types of, accidents and just studies on the human brain, how it works in different locations under different circumstances.
And what do you do now?
So now I operate Lindell Consulting, where I do similar work with human factor analysis and cognition. And a lot of my work is to do with similar stuff to this. I mean, I've testified in over 400 cases as an expert witness, and a lot of my work is related to premises liability, bar over service, slip and fall, trip and fall, and a variety of other very related injury accidents.
Now, you mentioned you've done cases about this. How many cases have you done?
Yeah, so roughly 400.
And have you testified before?
I have.
Just to know, what sides do you normally testify for?
I can go on both, either for the plaintiff or for the defendant. It just depends on what I'm hired for.
Have you ever had a case that deals with intoxication?
Oh, many times.
And Ms. Lindell, do you have any certification?
I do. So I am certified as an ergonomist as well as a human factor scientist.
What is an ergonomist?
So as I explained earlier, a human factor scientist focuses on the mental aspect of how a human would interact with a location in a cognitive way, what that would look like, where an ergonomist focuses on the physical aspect of how the human body would interact, what hazards would create a fall, what sort of issues with the space would lead to a human interacting with it in a way that's dangerous or posing a threat.
Now, Ms. Lindell, have you ever had any classes with toxicology?
I have taken forensic toxicology courses in the past.
Now, Mr. Lindell, you reviewed the facts in this case.
Correct.
What evidence did you review?
Yeah, so there were depositions that I reviewed. I reviewed all of the exhibits that were presented to me, with Avery Potter, his deposition. I reviewed the report by McPhee. I looked at a bunch of different scholarly and peer-reviewed sources on alcohol use and accidents. And I also conducted my own research at the actual site where the accident occurred.
Was there anything else you did?
Yeah, my firm conducted a retrograde analysis.
And what methods and principles did you use?
So in order to conduct my research on a case like this, I really had to use a wide variety of my life experience, including my education back to my time in psychology, up till my PhD work in human factors. And I also, used my multitude of years of experience analyzing different scenarios, and I feel very strongly about what I've done in this case.
And did you use those methods and principles to the facts of this case?
Applied directly to the facts, correct.
Your Honor, at this time, the defense wants to tender Mr. Lindell as an expert in ergonomics and factor-based analysis.
Members of the jury, expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion about a subject matter in which you believe them to be an expert. Like any other witness, you may believe or disbelieve all or any part of an expert witness's testimony. I will allow Dr. Lindell to give an opinion in this case. You may proceed.
Now, Mr. Lindell, what was your opinion?
So I had two opinions in this case. And my first opinion was that Mr. Leery was adequately warned by the warning sign that was located in the parking lot.
Your Honor, permission to publish what's already been pre-admitted as Plaintiff's Exhibit 3?
You may.
Just click.
Your Honor, may we have a moment?
You may. I think we should find an 11-year-old and ask him to do that.
Most. I'll
You may
just do this.
approach.
Yeah.
Please approach.
Well, can I approach the jury to show them?
Absolutely.
That'll be easier that way. So, what did you find out when you, well, tell us about your opinion.
Yeah, so my opinion was that the warning sign in the parking lot, outside of the ice house was an adequate warning for someone to see and know not to walk across the parking lot.
And Your Honor, this time retrieving what's already been pre-marked as Defense's Exhibit 2. Permission to approach the jury. Now, where was the location of that warning sign?
It was in the parking lot, in a place that was visible for most people in the parking lot, and especially highly visible for people that were exiting and entering the ice house.
Now, you mentioned that you did a site inspection, right? What did you find out there?
I did do a site inspection, and it was actually quite a worthwhile experience, because what I was able to find is that while moving throughout the parking lot, I studied, a wide array of people for a few hours during my time there. And what I noticed was that only about 5% of people walked straight through the parking lot. So about 95% of people were walking on the sidewalks as a reasonable person would after being warned.
How long were you there for your site visit?
A few hours for sure. It was quite some time I spent just, I like to do a deep dive into my research.
Now, based on reviewing the facts, would Mr. Leery had passed by that warning sign?
Oh, yes. Absolutely.
Pause for speculation, I'll
Thank you, Your Honor.
the objection, you gotta get me quick, objection is the word. Your Honor is me, objection preserves the record. Counsel, please, refrain from asking questions that call for speculation, okay?
Yes, Your Honor.
You can ask placement of the sign, but not who would see it. Yes, Counsel.
Your Honor, we move to strike that from the record.
Oh, it's already in the record, overruled. Go on.
Now, what else can you tell us about that sign?
Yeah, the way the message is laid out in that sign, it's very clear in my opinion, and it's a very effective sign. And just the way it's positioned, right in front of the ice house, the way it is that, it's pretty clear that you are warned not to walk in the direction that Mr. Leery walked. That's what it says on the sign.
Now, you mentioned you had a second opinion.
I did.
What was your second opinion?
Yes, so my second opinion was that the consumption of alcohol was the cause of his fall.
And what did you review to base that fact?
So I reviewed the toxicology report that was taken.
Your Honor, showing opposing counsel when's been pre-marked as Exhibit 72.
Your Honor, objection under Rule 702. He is not a certified toxicologist. He's been tendered as an expert in human factors.
Noted for the record, overruled, based upon the court's prior rulings. You may approach.
May I approach?
You may proceed.
Approach the witness.
You may.
Mr. Lindell, do you know Exhibit 72?
I do.
How do you know Exhibit 72?
It was reviewed by Lindell Consulting.
And what is Exhibit 72?
Exhibit 72 is the toxicology report of Mr. Leery when he was taken into the medical examiner's office.
And is Exhibit 72 a fair and accurate depiction of the toxicology report for Mr. Leery?
Yes.
Your Honor, at this time, the defense moves to put Exhibit 72 as defense's Exhibit 7. Permission to publish to the
Any
jury.
further objections other than those previously made?
No, Your Honor.
Okay. That will be received into evidence and you may publish.
Now, Mr. Lindell, what are we looking at here?
We're looking at a toxicology report that shows Mr. Leary's positive blood alcohol content for ethanol at 0.06.
And at what time was this report done?
This report was done approximately at 23:20, 2 hours and 20 minutes after the fall.
And now, is there a way to determine what Mr. Leary's blood alcohol would have been at the time of the fall?
There is, and that's something that my firm does a good job with. It's called a retrograde analysis.
Now, what is a retrograde analysis?
A retrograde analysis is a formula that is widely used in my practice, and what it does is it dates back in time what someone's blood alcohol content would have been, before the toxicology report was taken.
Now, did you yourself make this report?
Lindell Consulting made the report, but especially and in particular, it was my associate, Miss Christy Livingstone.
And is Ms. Livingstone certified to give a toxicology, to give a retrograde analysis?
She is a certified forensic toxicologist.
And is it common in your field of science to read another person's report?
Most definitely, all the time.
And has Ms. Livingstone conducted these reports in the past?
She has.
Your Honor, I want to showing opposing counsel was been pre-marked as Exhibit 73.
Your Honor, I object under 802 and 403. Stipulations 14 and 15 do not cover it.
Let me see what you got. No, don't pull it up.
Oh, it was multiple, that's why I was gonna pull it out. I just wanted-
I won't read you.
It's difficult to read.
Well, my ruling was that he could tell the members of the jury pursuant to 702 what he looked at. If he had looked at an airplane, that would not come into evidence. So I'll note the objection, and I'm gonna sustain the objection. He can talk about it, but it doesn't come into evidence.
You can talk about the report that he reviewed.
That he reviewed, but it doesn't come into evidence, because
Yes,
he
Your
did
Honor.
not prepare it.
Thank you, Your Honor.
My pleasure.
Now, Mr. Lindell, when you reviewed the retrograde analysis, what did it tell you?
Yeah, so I can break down the report for you. I've looked at it many, many times, and Lindell Consulting was involved in it, which is a direct affiliate of me, it's my company. And what this report showed was a low end, an average, and a high average of the blood alcohol content that could have been for Mr. Leery at the time of the accident. So, as we know, it was an 0.06, 2 hours and 20 minutes after the accident happened. And this retrograde analysis done by Ms. Livingstone, my associate, was done with a formula that applied it to 2 hours and 30 minutes before the, from the toxicology report in advance. And what this showed was that at the time of his fall, we saw on the lowest end a blood alcohol content level of 0.085, which is slightly over the legal limit in the jurisdiction that we're in. And that's on the lowest end. So based on our data, Mr. Leery was impaired, but that's just the low end. The average shows that he was impaired at an extent of 0.098, which is significantly over the legal limit. And at the high average, we saw that it was at 0.11, which was, that is quite the high blood alcohol content to have. It shows that really in any scenario, Mr. Leery was impaired. If you look at the retrograde analysis, it just shows a high level of impairment over the legal limit. And even if you look at the 0.06, it's still highly impaired.
You may continue.
Yeah, so, any way you look at it, Mr. Leery was impaired by alcohol, and that was why he fell. A reasonable person in his shoes would have seen the sign and would have been able to watch their step, in my professional opinion.
And in your opinion, if we were to take, based on that report, what signs would Mr. Leery show of intoxication?
Yeah, just from, what we saw, he unfortunately tripped on the sprinkler head, and fell on his walk. First of all, had he adhered to the clear warning, which he would have seen, as a reasonable person would, had he not been impaired most likely, that, he wouldn't have walked the way he did. But he did anyways, and that was, in that small 5% minority of my study at the field. But even then, he then tripped on a sprinkler head, and that's a clear sign of impairment, not being able to control his body. What we study as human factor scientists all the time is that loss of control in the body and the mind. And it was a clear display of that in this case.
Would his age have been the reason why he was stumbling?
Definitely could have been a contributing factor, but his blood alcohol content alone is enough for anyone to have been potentially having issues.
The questions at this time, Your Honor.
Cross-examination.
Me on the screen.
Good evening, Dr. Lindell.
Good evening.
You're a human factors expert,
I am.
not a certified toxicologist.
Taking courses in it, but I'm not. But no.
Those courses did not enable you to become a certified toxicologist?
Well, why would I? I own my own consulting firm and I have employees that do a perfectly good job at it and are.
My question was your coursework enough to get you certification?
No, but I don't see why that matters.
You wrote a report in this case,
I did.
and you stand behind that report.
Yes.
The defense hired you to sit here today.
I was hired to sit here as I have been in 400 other cases.
$750 an hour for your report?
Yes, sounds about right.
$1,500 an hour to sit in here today.
Most likely.
$27,000 total.
Okay, yes, that sounds about right.
Yet, in your report, you didn't factor lighting.
Wasn't hired to factor lighting.
The defense never asked you to factor lighting.
Not something that I was hired to do. I was hired to provide a report on what Mr. Leery's condition was mentally and to offer up information on his impairment.
But you read our expert's report on lighting, so you knew it mattered.
I wasn't hired to do that.
But you read Mr. McPhee's report.
Absolutely, but again, had I been told to do the lighting, I would have done it, but that wasn't something that was essential in this scenario for me. I was told to do one thing, and what I did was I made a report and gave my opinions about his impairment being a significant cause of his fall.
As you said, you did not, as the defense didn't ask you to.
I don't have anything written down about lighting.
Let's talk about some of the factors in the case. In this case, you referred to the sprinkler in question as a fairly obvious hazard.
Most definitely, yes.
And the fall took place on September 7th of 2024.
Correct.
You went out to the lot on October 20th, 6 weeks later?
Correct, that's where I did my inspection of the field.
Yet you didn't see the sprinkler head.
Was
Objection, Your Honor, relevance of not seeing the sprinkler.
Let me see where you're going with this.
I mean, my report was to study human behavior of observing a sign, which 95% of people followed. My job here wasn't really to
Dr.
look up.
Lindell, it's a simple question. Did you observe the sprinkler head?
Not necessarily.
You gave your sworn statement on November 15th of 2025,
Correct.
and when we showed you the exhibit of the median, you couldn't see it either.
Correct.
In fact, you never saw the sprinkler head in person.
No, I didn't.
And you said this was a fairly obvious hazard to an impaired person.
What must have been?
Wouldn't it be a hazard to a sober person?
Absolutely, it would have been a hazard to a sober person, but a sober person probably would have seen it.
Yet you couldn't see it when we showed you the picture during your sworn statement.
I wasn't especially looking for the sprinkler head, though. My job here was to really see how humans were interacting with their environment, which is my job as a human factors analyst. And what I was doing is I was looking to see, was this sign something that actually was effective in this parking lot? And what I found was that 95% of people adhered to the sign. It's really what I was hired to do, not analyze sprinkler heads.
As you said, the sign in question, the sign says nothing about sprinkler heads.
No, but it says not to walk in the path where the sprinkler head was.
The sign says nothing about lighting.
I don't believe it does. I'd have to see the exhibit again. I believe it. Yes, I don't think it does say anything about lighting.
The sign says nothing about tripping hazards.
For the record, Plaintiff Exhibit 3.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. So it says nothing about lighting. No, you're correct. But it does say that walking through the parking lot should be avoided.
The sign wasn't lit up.
The sign is fairly large.
In your own report, you studied several things. One of those things is that 50% of people don't read signs.
The sign, I mean, again, my report in the past did say that, but if you look to the most important aspect of my research in this case, it's the point that I've been talking about all day, and it's that 95% of people didn't walk through the parking lot. They walked on the sidewalk.
You can't
You
definitively.
have one last question that you can ask this gentleman in front of the jury.
You can't definitively tell us what percentage alcohol played a factor in this case.
I can't give a definitive percentage of what percent it played, but what I can tell you is that from Lindell Consulting's records and information that we took with a retrograde analysis, on the low end, on the medium end, and on the high end, there was over the legal limit of impairment. So I would say, in my professional opinion, of over 400 of these, that Mr. Lindell was, Mr. Leery was most certainly impaired and most certainly was impacted by that impairment.
Thank you, counsel. All right, members of the jury, getting ready for our closing arguments. I do need to talk to the lawyers about a few motions. Dr. Lindell, thank you for your presence here.
Thank you very
You may
much.
step down.
Thank you, Your Honor.
I know you want to stay with me, Mr.
Oh,
Dr.
please,
Lindell, but you gotta go.
Thank you.
Okay, look here. We go with the talks about
Counsel, if I can just see you all for a moment, briefly sidebar. I know play some music or something, so that I'll be here in the corner.
Thank you.
33 get the okay, I'm going to allow the attorneys to do their closing arguments. Okay, because I know you all wanna get busy with what you do, your job is to deliberate and need to do it if possible. What I'm going to do is each side will give a closing argument, but the plaintiff goes first. As I said, they have the burden of proof. Please don't make up your minds about this case until I have given you the instructions that you have to follow. Each side's gonna have the same amount of time. There will be no split in the time. Whoever's gonna do the closings for either side, just go all the way through. Okay? All right, so if you're giving the thumbs up?
Yes.
All right, ready to go. All right, plaintiff, Ms. Baleanu, you may do your closing argument at this time.
Thank you, Your Honor. Members of the jury, this case was about choices. For years, Witter Development knew. They knew about their lighting conditions, they knew about the route customers were taking to their cars, and they knew about their exposed sprinkler heads. And year after year after year, they had a choice to make. Fix these conditions or ignore them. And Witter Development chose to ignore them. And unfortunately, on September 7th, 2024, Jamie Leery suffered the consequences of those choices. Now, we as the plaintiff had a burden that we carried and met throughout this entire trial. We had to prove that the defendant was negligent by a preponderance of the evidence. All this simply means is that a fact is more likely true than not true. Now, to prove that the defendant was negligent, we had to prove 3 elements. Starting off with the first element. The condition of the parking lot posed an unreasonable risk of harm. All this means was that their parking lot was dangerous. Members of the jury, this was their parking lot. This is the exact landscape median that Jamie Leery stepped on, all because he was trying to avoid a puddle, and the one that he ultimately tripped over that sprinkler head, causing him to hit his head on the pavement and die. This is the landscape median that took Jamie Leery's life. You heard today from Cameron McPhee, an experienced landscaping expert. He got up here and he told you that a retractable sprinkler head that doesn't retract back into the ground is malfunctioning. And he told you that under the Wilmington City Ordinance, it is demanded that these sprinklers be removed. And he also told you that there was no purpose for these sprinklers, not during his investigation, not a week before during Jamie's fall, and not even for the 10 years before that. But Witter Development left these unused, malfunctioning sprinkler heads in their parking lot. You also heard today from Avery Potter, a tenant of the defendant. She got up here and she told you just how bad these lighting conditions really were. She told you about the traumatic experience that she went through when she saw Jamie Leery disappear into the darkness, and as she ran over to try and see what exactly he tripped over, she couldn't even see the sprinkler head because of how dark it was. When taking all that evidence together, that proves that their parking lot was dangerous. Now, the second element that we've proven today. Witter Development knew of the dangers in their parking lot. Today wasn't the first time that the defendant heard about these conditions. They knew, and they knew for 10 years. Avery Potter told you about 2 written email complaints she sent to her landlord, Logan Witter. In both of these email complaints, she complained about how bad the lighting was in this parking lot. In both of these emails, she begged her landlord to do something about the lighting. And in both of these emails, Avery Potter told Logan Witter that there are customers complaining, tripping, even falling because of how dark it was in this parking lot. And never, in a million years, would Avery Potter think that it would be her lifelong friend, her old college professor, her advisor, to be the one to suffer the consequences of the dangers that she's been trying to warn her landlord about for years. And Witter Development also knew about the path that customers were regularly taking back to their cars. Witter Development knew that not every single customer was using the sidewalk, and that this wasn't just a silly choice of Jamie Leery's after a few old fashions. And as to those exposed sprinkler heads, the Witter Development knew about those for 10 years. In fact, Logan Witter's words back in 2014 were, "It's just a couple of sprinkler heads sticking up out of the ground, right?" Back in 2014, she had a choice to make. Spend $4,000 to $5,000 and remove these unused, exposed sprinkler heads, or wait for a disaster like what happened to Jamie Leery to occur. Members of the jury, we know the choice that they made. Lastly, the third element. Witter Development failed to protect Jamie Leery from the dangerous conditions by failing to warn him and failing to make those conditions safe. Witter Development knew that their parking lot was a walking hazard, but all they chose to do was put up one sign. This was the sign. One sign, their entire parking lot. The sign didn't mention the exposed sprinkler heads, didn't mention the landscape medians. The sign wasn't illuminated. And they only chose to put up one sign in their entire parking lot, outside of one restaurant. They chose to put up one sign right over here, right outside of the ice house. Riley and Jamie's car was parked all the way over here. Members of the jury, let me just show you the distance between where this sign was located and where their car was parked that night. The sign was posted right over here. Riley and Jamie were parked all the way over here. So they couldn't see the sign when they first got into the parking lot. In fact, the only time Jamie could have seen this sign was right before he left the ice house. In fact, the only time anybody could have seen this sign was right before leaving the ice house. And you heard today from the defense's own expert witness, Lindell, that approximately 50% of people completely ignore warning signs. And nobody here today could confirm whether or not Jamie Leery even saw this sign. And Avery Potter told you that this sign didn't resolve her concerns. She said it was like putting a Band-Aid over a bullet wound at best. Now, the defense wants you to focus on what Jamie Leery did on September 7th, 2024. But members of the jury, that's not what this case is about. A few old fashions Jamie Leery had that day didn't cause lighting conditions to fail under city ordinances. And a few old fashions Jamie Leery had that day didn't cause exposed sprinkler heads to remain in their parking lot for 10 years. A few old fashions didn't cause the defendant to repeatedly ignore complaints. Riley Leery came to Wilmington on September 7th, 2024, for what was supposed to be an early birthday celebration for his father. And instead, he sits here today with us, grieving the loss of his father, all because of the defendant's choices. Members of the jury, The defense wants you to focus on the bias or the past history between our expert and the defendant. However, the defendant couldn't even confirm whether or not that if the subcontractor they used to check the lighting had their tool calibrated. And furthermore, you heard from our expert that he is not here today testifying to get revenge or to follow up on that threat. He is testifying on behalf of his experience, knowledge, and skill for the past 20 years. And Avery Potter told you that she saw Jamie Leery walk all the way back there to his car. And she didn't see Jamie Leery stumble once. In a moment, the judge will instruct you to make a verdict regarding the defendant's negligence. For question number 1, where it asks, did the negligence, if any, of the persons named below proximately cause the injury in question? The only answer that is reasonably supported by the evidence you saw and the testimony you heard in today's case is by marking a check mark next to Witter Development, LLC. For the second question, where it asks you to assign percentages to those you find caused the damages identified in response to question number 1, yet again, the only answer that is reasonably supported by the evidence you saw and the testimony you heard in today's case is by assigning 100% fault to the defendant. However, if after everything you've seen and heard today, you believe that Jamie Leery slightly contributed to what happened on September 7th, 2024, I submit to you an alternative. The answer to question number 1 is still yes as to Witter Development, but to assign a 10% fault to Jamie Leery, but a 90% fault to Witter Development. Because members of the jury, the dangers in the parking lot were inevitable. At one point, that sidewalk was going to end, and at one point, Jamie Leery was going to come in contact with the dangers in their parking lot. For years, Witter Development turned a blind eye to the dangers in their parking lot. But today, they must be held responsible. Thank you.
On behalf of the defense?
Yes, Your
Yes,
Honor.
Your Honor.
Get this technology figured out. Okay, Your Honor, may I proceed? Members of the jury, plaintiff just told you that this is a story about choices. And the defense? Well, we agree. This is in fact a story about choices. However, it is not only a story about choices alone. It is also a story about personal responsibility. Now, I'm not gonna walk you through every moment of that fateful night because you were all here and you heard what happened. What I'm here to do is I'm here to gather the evidence that we heard at trial today and present it to you so we understand what's truly going on here. Because the plaintiff wants you to believe that this is simply a story about a sprinkler and a streetlight. But there is so much more to the story than that. Because members of the jury, it is a fact that before September 7th, 2024, the plaintiff cannot point to anybody who had any problems with this sprinkler system. For the 20 years that Witter Development has owned this property, nobody has had any problems regarding a sprinkler system. So if for 20 years the property has been safe, what really changed on September 7th, 2024? Well, in order for us to understand and answer that question, we have to look past the simple narrative that the plaintiff is telling us and look at who the plaintiff has telling that story. Now, I want you to take a look at this quote. It says, "Do not let bias, prejudice, or sympathy play a part in your decision." Members of the jury, that is a charge for you here today. And you'll see it at the end of these proceedings and in your jury charge form. However, it is not just applicable to you, it also applies to witnesses in this case. Members of the jury, bias is always at issue for a witness. That is important, so I'll repeat it. Bias is always at issue for a witness. And now the plaintiff might try to downplay that fact, but that's not for the plaintiff to decide, it's for you to decide. Whenever a witness takes that stand, you must always consider what bias they may have come in with. And with that being said, enter Cameron McPhee, plaintiff's expert witness in this case, the person who virtually all of plaintiff's case hinges on as their expert witness, and the person who came into this courtroom today with an axe to grind against Witter Development. Because Cameron McPhee knew of Witter Development before he ever took that stand today. Cameron McPhee knew of Witter Development before he was deposed on October 1st. And Cameron McPhee knew of Witter Development before Jamie Leery ever encountered that sprinkler head. And how did Cameron McPhee know of Logan Witter and Witter Development? Well, he knew them because he sued them in the past. Plaintiff's expert witness sued the defendant in this case who they are here testifying against today. That is the person that the plaintiff wants you to put your faith into. And of all of the landscapers in Wilmington, of all of the landscapers in Hanover, of all of the people in the world, the plaintiff decided that this was their guy. The guy who offered himself before he could even be asked. And the guy who didn't even bother to have the light meter calibrated before he went to that parking lot. And additionally, members of the jury, something that you'll note is while we were talking to Cameron McPhee, we know that he went to the parking lot. We know that he did an inspection. We know that he used a light meter, and yet we haven't seen any of those measurements. Not one. What happened to the measurements? It's almost as if the plaintiff knows. They know that the tools are unreliable, and they know that this witness is full of you know what. But that didn't matter. This was the perfect expert for the plaintiff, a friend of the family and an enemy of the defendant. And moving on, let's talk a little bit about some of the other people that we heard from in this case. So if we can't trust what Cameron McPhee is saying, who can we trust in this case? Well, the plaintiff gave us another witness, Avery Potter. And Avery Potter is the same person who continued serving Jamie Leery despite the fact that she saw him stumbling in her bar. Avery Potter is the same person who alleges that she went out there into the parking lot with Jamie Leery and Riley Leery, and yet Riley Leery said nothing of that. But if we are to grant that Avery Potter went out there, let's recall where she was. Avery Potter stated that she was right around here, and she watched Jamie and Riley Leery walk out to that landscape median right about there. And as we saw from plaintiff's demonstration, you see the equidistance of how far it is, but wait, I thought you couldn't see anything in this parking lot. And yet Avery Potter saw perfectly fine. It's almost as if the lighting in the parking lot was just fine. And considering that, let's talk about the only qualified witness in this case, Dylan Lindell. As we heard from Dylan Lindell, we heard about the devastating consequences that the choices made by Jamie Leery had in this case. Even granted that Jamie Leery had only an 0.06 blood alcohol level, his faculties and motor skills would have been substantially impacted. And we don't even have to grant that the blood alcohol level was an 0.06 because we heard Dylan Lindell testify about that retrograde analysis and that Jamie Leary's blood alcohol level was as high above the legal limit. So at sometimes as high as an 0.11 or 0.08, doesn't really matter. Either way, it was above what the legal limit is and showing that he was intoxicated. Additionally, we heard Dylan Lindell talk about this warning sign. And based on the positioning of the warning sign, it is likely that Jamie and Riley Leery walked right past that warning sign. And taking a look at the warning sign, it doesn't get much louder than this. Danger in big bold letters with a red background. Members of the jury, if someone chooses not to heed the warning sign that's there for their safety, what happens to them is out of our control. Members of the jury, Witter Development could not guarantee a risk-free parking lot. No property owner can. But the standard here is not perfection. The standard here is reasonableness. And Logan Witter and Witter Development acted reasonably at every turn in this case because the plaintiff told you that Logan Witter didn't do anything in response to complaints. Complaints from who? The only person who complained was Avery Potter. The only tenant who complained was Avery Potter. We didn't hear anything from any other tenants complaining about Logan Witter and Witter Development. And Logan Witter chose to have that sign put up, and every time a complaint came through, Logan Witter did something about it. Avery Potter admitted to that. Now, finally, we are going to move to the end of this case, and I want to thank you all for taking the time to be here. Members of the jury, Witter Development did not put that final cocktail in Jamie Leary's hands. And at the end of this, you will hear from the Honorable Judge Holmes, and she will instruct you on the law. You will receive a jury charge in this case and a verdict form, and you will be sent on your way to deliberate. And while you do so, we ask that you remember this. It is the plaintiff who bears the burden of proof in this case. We don't have a burden. The plaintiff has the burden to prove to you by a preponderance of the evidence that Witter Development was negligent in this case, which means a greater weight of the credible evidence. Think about this, where is the credible evidence? Coming from Cameron McPhee? That's the credible evidence? Think about that as you are in the jury room. And with that thought in mind, we ask that you find the defendant not liable in this case. Thank you.
Thank you. Ladies and gentlemen of the jury, just 1 second.
Oh, sorry, Your Honor, may I quickly do a rebuttal?
Remember I said we would do it all in one? because of the time, counsel, you gotta listen to the court. Members of the jury, the lawyers really wanna keep talking, but it's now time for me to put you to work. The lawyers have presented their closing arguments, and I'm gonna keep reminding you that what the lawyers say is not evidence. And you cannot consider their statements to be evidence, but hopefully you have listened very carefully because they know the case and the closing arguments were there to help you understand what this case was about. It's almost time for you to discuss this case, but I want to give you these instructions. You're going to get 2 verdict forms, and you heard that previously from the attorneys. And these are the instructions for answering those questions. Do not let bias, prejudice, or sympathy play any part in your decision. The plaintiff's case, or the claim in this case, is for negligence. With respect to the condition of the premises, Witter Development LLC was negligent if, 1, the condition or conditions posed an unreasonable risk of harm, and 2, Witter Development LLC knew or reasonably should have known of the danger, and 3, Witter Development LLC failed to exercise ordinary care to protect Jamie Leery from the danger by both failing to adequately warn Jamie Leery of the condition or conditions and failing to make that condition or those conditions reasonably safe. Ordinary care, when used with respect to the conduct of Witter Development LLC as an owner of the subject premises, means that degree of care that would be used by a premise owner of ordinary prudence under the same or similar circumstances. Proximate cause means a cause unbroken by any new and independent cause that was a substantial factor in bringing about an injury, and without which cause such injury would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person using ordinary care would have foreseen the injury or some similar injury might reasonably result therefrom. There may be more than one proximate cause of an injury. The term preponderance of the evidence means the greater weight of credible evidence presented in this case. If you do not find that a preponderance of the evidence supports a yes answer, then answer no. A preponderance of the evidence is not measured by the number of witnesses or by the number of documents admitted in evidence. For a fact to be proved by a preponderance of the evidence, you must find that the fact is more likely true than not. The plaintiff has the burden of proof on their claim of negligence. That is, the plaintiff must prove that one or more defendants were negligent by a preponderance of the evidence. An employer is vicariously liable for its employee's actions while the employee is acting within the course and scope of their employment. The defendant admits that Logan Witter was acting in the course and scope of employment at all times relevant to this case. The defendant has pled affirmative defenses of comparative negligence. The defense asserts that the negligence of Jamie Leery was a proximate cause of Jamie Leery's injury. With respect to Jamie Leery's negligence, means failure to use ordinary care, that is, failing to do that which a person of ordinary prudence would have done under the same or similar circumstances, or doing that which a person of ordinary prudence would not have done under the same or similar circumstances. With respect to Jamie Leery, ordinary care means that degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. The definition applying to proximate cause that I have previously given to you applies to any comparative negligence defense. The defense has the burden of proof on their affirmative defense. That is, the defense must prove that Jamie Leery was negligent by a preponderance of the evidence before the defense would prevail on that issue. We have the forms, and each of them are marked. We have verdict form question 1, and then verdict form for question 2. I won't read them in detail, but question 1 reads as follows. For purposes of this question, Did the negligence, if any, of the persons named below approximately cause the injury in question? And then you're told to answer yes or no for each of the following. So you have to write an answer on both of the blank lines. Was Witter Development, and you put yes or no, or Jamie Leery, yes or no? If you answered yes to question 1 for Witter Development, LLC, and answered yes to question number 1 for Jamie Leery, then answer the following question on the second, okay? Question number 2, for purposes of this question, you should only assign percentages to those you find caused the damages identified in response to question number 1. The percentages you find must total, in total, 100%. So whatever the math is, you have to make sure that whatever you put on the lines for Witter Development and Jamie Leery, they have to total, in total, 100%. The percentages must be expressed in whole numbers, so don't put 0.5 or 0.6 or 0.2. It has to be in whole numbers. The percentage of responsibility is not necessarily measured by the number of acts or omissions found. For those found by you to have caused the damages, if any, to Jamie Leery, find the percentages caused by Witter. You put a number there if it's possible, and Jamie Leery if you find that there's a number. And then the foreperson will sign each of the question forms. When you get to the jury room, the first thing you should do is elect a foreperson. The foreperson can be a male or a female, doesn't matter. But the foreperson presides over your deliberations like the chairperson of a meeting. Go to a meeting, you got a chair. And so, but the chair's job is to make sure that everybody participates and has a voice. Anybody that wants to be heard, please, chair, whoever the foreperson is, make sure that they have their voice and that they are heard. Also, during the course of this trial, I've allowed you to take notes. And as I mentioned earlier, your notes are for your eyes only. They should not be compared with the other jurors to say, this is what I heard. It's to waken your memory. So don't compare notes. And just because somebody may have doodled a little bit and taken a half page of notes, doesn't make your notes more important than the person that took up the whole steno pad. So whatever you wrote, that's for you to help you participate in the deliberation. The exhibits that have been introduced in evidence, I'm going to make sure you get all of them. I can't send the screen back, but I'm certainly going to make sure that these are properly marked and you'll have them at your whatever time you want to take. I do not put time limits. Our appellate courts have said do not time the jury's verdict. So you take as much time as you need or as much time as Cantor will allow you to have to reach your decision. Also, if you have any questions for me about anything, it has to be in writing. So you don't ring the buzzer and say, Judge, I didn't talk to you. It has to be in writing because the lawyers need to know and see and hear to make sure that I'm not trying to influence you in any way. I've covered notes, I've covered the foreperson, I've covered the exhibits and the questions in writing. I think you're good to go. My bailiff is going to I'm going to give them, I personally made this folder for them. Take them to now for their deliberations. And we'll be here waiting. Yes.
Would you like me to bring the exhibits to the jury?
No, you can't take them in that. My deputy is going to do, my bailiff is going to do, but you all are going to confer with me and to make sure that we're going to hand them what they need to see. So you all will stay back here with me and we'll go over to make sure that everything's in. My bailiff is going to they're in your care and custody and control. Don't let anything happen to my jurors. Okay, follow the leader.
All rise.
Yes, Your Honor, if you just give me a moment to gather
And that's another thing I'm gonna put, I put down for my critique. Y'all gotta be a little bit more, and you gotta listen to the court. I've been in trials where I've made rulings and the lawyers are just, and what happened to you has happened before, people who are members of the bar. Remember I said we're not gonna split it, do it all in one? That's what I meant, because sometimes time gets away from us. If this were an actual trial, I probably would have given you a couple more minutes. But it's important to really listen to the court. So have a seat while the defense is talking and I'll hear rebuttal. So you get to stand.
All right, Your Honor, the defense at this time moves for a directed verdict in this case, viewing the evidence in the light most favorable to the non-moving party, which is the plaintiff. No reasonable jury would rule in their favor for the following reasons. The plaintiff bears the burden of proof in this case to prove to this jury by a preponderance of the evidence that, which is a greater weight of credible evidence, that Witter Development was negligent in this case, and they have failed to meet that burden. So the elements that they were required to meet by a preponderance of the evidence were the condition posed an unreasonable risk of harm, Witter Development LLC knew or reasonably should have known of the danger, and Witter Development LLC failed to exercise ordinary care to protect Jamie Leery from the danger by both failing to adequately warn Jamie Leery of the condition or conditions and failing to make the condition or conditions reasonably safe. Well, let's talk about the condition or conditions posed unreasonable risk of harm. Unreasonable risk of harm, but we know that for 20 years there were no incidents with the sprinkler head, which is the stipulated cause of the fall. It is not unreasonable to have the sprinkler heads or the sprinkler system still in the median because they were not posing any risk of harm to anybody. They were meant to be they are retractable sprinkler systems and they were meant to be flushed to the ground. And we don't know for how long this specific sprinkler head was up for. And as we know, Witter Development had routine maintenance checks done at the property. And those routine maintenance checks, there was never any issues regarding the sprinkler heads, whether they were up or not. So we don't know how this specific sprinkler head got up. So the sprinkler head is not a dangerous condition as it has been characterized. And another thing with the adequacy of the lighting, well, we haven't seen any evidence regarding the adequacy of the lighting, so I'll leave that there. Witter Development knew or reasonably should have known of the danger. Well, again, as we heard during trial, and I don't know if I could talk about what the defense said since it's afterwards, but I'm just going to say the defense testified, Logan Witter testified, that she did not know of any of this specific sprinkler head being exposed. None of the routine maintenance checks that were done on the premises, there was no notification regarding any issues of the sprinkler system, and other tenants also did not make Witter Development aware of this sprinkler head. And so if nobody knows that this specific sprinkler head is up, how is Logan Witter supposed to know? She can only rely on the landscapers that she has come out to say, hey, this one is up, and rely on that. And aside from that, there's not really much that she can do. And I know the plaintiff argues that they could have taken it out, but that's not the law. The city never gave them a citation for having these sprinkler heads still in the median. The city never warned them to take out these sprinkler heads because they're not supposed to be in the median. There was no indication or there was no law that the plaintiff can point to that required these sprinkler heads be removed. And finally, Witter Development failed to exercise ordinary care to protect Jamie Leery from the danger by both failing to adequately warn Jamie Leery of the condition. Well, we know that Jamie Leery was adequately warned of the condition because of the sign. And I understand that there is some controversy regarding, oh, it was only one sign and there was no illumination of the sign and all of that stuff, but where the sign was placed and where Jamie Leery and Riley Leery left the ice house, the sign was placed in a way where it was viewable to Jamie and Riley Leery. And also, if we are to grant that Avery Potter saw Jamie and Riley Leery walk out there, well, Avery Potter knew of that sign as well and had the opportunity to warn as well. Not that it's necessarily Avery Potter's responsibility, but the point is that the sign was there, it was viewed by people, and people knew about it. So that is adequate warning in this case. And that is the defense's directed verdict, Your Honor.
Your Honor, on this motion, the court views the evidence in light of the favor of the non-moving party and draws every reasonable inference for the non-moving party's favor. The court does not weigh the evidence, and it does not decide credibility. The motion may be granted only if the evidence permits a single conclusion, and that the conclusion is a verdict for the defendant. The defendant has stipulated that it owed Jamie Leery ordinary care, including the duty to discover dangerous conditions to warn of them and make them reasonably safe. The defendant has stipulated that Jamie Leery tripped over the subject sprinkler head, and the defendant has stipulated the cause of death. Duty and causation are off of this motion. The jury heard readings of low lighting and at that exact location of the sprinkler head. Every one of them falls below, my apologies. The jury heard that the irrigation system beneath the median had been dead for a decade and served no purpose. And defendant's own expert agreed that a sprinkler head protruding from the ground is a tripping hazard. And whether or not a person is impaired or not. The charge asks about the conditions, so the jury may weigh the head and the darkness together. This element is disjunctive. In February 2014, defendant priced the removal of the sprinkler head, and its own chief financial officer wrote that it may be worth the money to get rid of the ones they knew were malfunctioning. Mr. Witter declined to spend the money. The manager of the tenant bar wrote to him twice about the darkness in this lot. Regarding the third element, this element is conjunctive and the plaintiff has evidence on both halves. On warning, the only sign in the lot identifies no hazard at all, and the defendant's own expert testified that a warning is effective only if it is read. That he does not know whether Jamie Leery read it or not, and that roughly half of the people ignore signs entirely. On making the conditions safe, nothing on that median was removed, capped, painted, or lit. Mr. Witter conceded that painted curbs do little without sufficient light. He priced the repair and declined to buy it. A jury may call that a choice. Regarding the alcohol, the court's charge states that there may be more than one proximate cause of an injury. The only measured blood alcohol in this case is a 0.06, and the legal limit in this jurisdiction is a 0.08. Hanover is a comparative fault jurisdiction, and comparative negligence is defendant's affirmative defense on defendant's burden, and the allocation belongs to the jury. Plaintiff respectfully asks the court deny the motion in its entirety. Should the court have any concern, plaintiff has no objection to the court taking the motion under advisement and letting the case go to the jury.
Which I already did. Any rebuttal with regard to that?
Yes, Your Honor. So the plaintiff did not address in its response exactly how the condition was an unreasonable risk of harm, or at least not that I heard. Like I said, the plaintiff did not address the fact that there were no incidents regarding the sprinkler head for 20 years of Witter development.
We really don't know that. We just, that's hyperbole and speculation at best. Just because it wasn't brought out in this case, and I wouldn't allow previous incidents in this case, doesn't mean that there weren't any issues. And I think you pointed out, there was, something about the sprinkler heads and Mrs. Witter, and y'all gotta get these genders. In front of the jury, you said, he, I want to hit you, so can't you see, it's a woman. You know, so y'all gotta, pivot, as best you can. That she was at least made, aware that some sprinklers were out or something, and wanted to see, to remove them, and the $45,000, and she said, no, I'm not spending that, for these people. So there's some issue with the sprinklers, okay? I mean, unrefuted issues, because the email came in, and you all gotta remember the stipulations that you all entered into, specifically stipulation 7. I wanted to scream at you, you kept asking me for permission to introduce it into evidence. I think you all agreed and you stipulated, with the only provision is that you can make objections if you've changed your mind. But it says, all exhibits are deemed authentic and are true copies, meaning they are what they purport to be. All parties reserve the right to raise other evidentiary objections to the admission of any exhibit at the trial of this matter. So if it is what it is, that's what it is. So, I just went along with the flow, but unfortunately, I don't think they told you, I'm a judge that reads. I don't care if it's 1,800 pages, 2,500 pages, I'll stay up all night and I read what you plead. So I know the word on the street is that judges don't read. You never know who you're gonna get, so you gotta know the lay of the land. I read everything. I didn't get this scenario until Friday night. And here we are on Wednesday, and I've read every depo, every page of, that's why they need to do it. I mean, if I had more time, I could tell you page and line, but just remember that. But getting back to the directed verdict, I don't know that you can't say, because you kept saying, and we know. I don't know that, and I do know that there is an exhibit in evidence that alludes to problems with sprinklers. So that's enough to defeat a motion for directed verdict. The lighting in the area. There was testimony that the expert witness, Mr. McPhee, could not say whether or not that the lights were out on the 7th of September, because he went out on the 14th. And nobody testified that, all we kept hearing is, I guess you took it for granted that it was poorly lit, but we don't know, what did it look like in actuality on the 7th of September, 2024? I thought that was a fatal flaw, so I can't direct a verdict based upon, the lighting, because the pictures we see show dark, but the pictures only show a vantage point, a vantage area. And I don't know, why didn't the defense go out and take pictures? We're using Mr. McPhee's pictures, because you asked him, you took it yourself. Yeah, he took it, So he was gonna take anything that was going to uphold his opinion of what was going on in that parking lot. And thirdly, the sign. You kind of missed it because Mr. Lindell, your expert, testified that he went out personally and he watched people. And he said that 95% of the people that he saw adhered to that sign. There's only 5% that did not. And I'm saying, what are they asking him this? It's your witness and he's killing you. So a directed verdict is kind of like a summary judgment made at the end of all the evidence. A summary judgment is before you get to trial. A directed verdict is the trial is had, and so judge, looking at this evidence in the light most favorable to the plaintiff, and say yes to everything that the plaintiff said. That's basically what you're saying in a directed verdict. And in this case is a case of credibility. The witnesses, and judges cannot, under any circumstance, unless the witness testified that they saw purple bunnies jumping up and down, you know, there's some competency there. It has to go to the jury. It's a jury question as to whether or not somebody with a 0.06 blood alcohol level was conscious enough to be reading signs, and did he contribute to his own demise? That's the sole basis of why we're here. So I could not grant a directed verdict under any circumstance. I would not have granted a motion for summary judgment either, because it's a fact issue. And the trier of fact now has these facts in their possession, and they'll come back with whatever verdict they think is proper under these circumstances. And they won't be swayed by prejudice, bias, or sympathy, or anything like that. So the motion for directed verdict, as stated, is denied.
Yes, Your Honor.
Okay. Now, I guess the jury should be back by now. I kind of stretched it out to 15 minutes, just let's see what they had to say. And then I'm gonna let them critique you also.
Thank you. Good shit.
You don't need to raise our directive.
Y'all wanna talk settlement in the hallway? Normally what I make my rule is Judge, can we have 5 minutes in the hallway? Y'all wanna talk settlement?
It's time to settle this case.
Okay. Mrs. Witter, how much you willing to give up in this case?
Nothing.
50K.
You can't be nickel and diamond over here on this one, because you will pay if that jury comes back. And you look, Jamie, Riley, you already a lawyer. You do products liability and mass torts. So you don't need the money. What you gonna do with all this money?
Exactly.
Your brother and sister, they're adults. Y'all are adults. Y'all should get a job, even flipping burgers.
There's 6 grandchildren, Your Honor.
They can get jobs when they grow up.
They can make a soccer team, win some games.
So how much you willing to part with? Never mind, time's up. Bring in my jury. You snooze, you lose.
All rise.
All right, ladies and gentlemen, you all may be seated. The record will reflect the presence of all the plaintiffs and the defense. And we have the members of the jury back from jury deliberations. And I should have just asked the foreperson to print his or her name. I knew I was gonna get, the first time I ever left it off, I got circles and dots. So, who's the foreperson? Okay, great. Can you tell me your name, Madam Foreperson?
Yes, Camilla, Camilla.
Camilla. E?
No, A.
A, okay, Camilla?
And Galletti, Galletti.
Gall.
E.
E.
Tti.
E-T-T, Galletti. Okay, great, thank you. My sister's name is Carnita, so I should be able to say Camilla. All right, you all have reached a verdict in this matter, and so I'm gonna publish. Normally I would have my clerk do it, but my clerk couldn't stay overnight. All right. As to question 1, for purposes of this question, did the negligence, if any, of the persons named below approximately cause the injury in question? Answer yes or no for each of the following. Witter Development, LLC, yes. Jamie Leery, yes. We go to page 2 or question 2. Question number 2, for the purposes of this question, you should only assign percentages to those you find caused the damages identified in response to question number 1. The percentages you find must total 100%. The percentages must be expressed in whole numbers, and the percentage of responsibility is not necessarily measured by the number of acts or omissions found. For those found by you to have caused the damages, if any, to Jamie Leery, find the percentage caused by Witter Development LLC, 80%, Jamie Leery, 20%, and it does total 100%. Thank you, members of the jury, for your time and consideration in this case. This case is now ended, and I'm gonna let you all talk to us. I know there's gonna be remitter, motion for new trial, all those other motions. But just for tonight, if only for one night. Can we talk to the Stand by, because I'm gonna keep my jurors all night. There's food over there for them. I'm gonna let you all have at them first. Anything you wanna say, how it was conducted. I am a real judge, sometimes. So you can ask us any questions, how you felt about it, how'd you come up with the percentages? And I think they filmed your deliberations.
We hope not. If my mom is watching, I'm sorry. I'm sorry, Mom. I love you.
Oh, man.
I think you guys did an amazing job. I think you guys did really good. I think you guys did great.
You can be,
Yeah.
this is gonna, how many levels of law school? Graduates, second year, first year?
We're on our third year now.
Okay, so everybody's second year going to third.
Going into my second year, Your Honor.
Okay, so you were a newbie.
Yes, Your
You're
Honor.
the baby in the group.
Yes, Your Honor.
You just found your 1L, where your seat is, and then you messing around with these people that have been around for a long time.
I'm looking forward to taking evidence.
All right, look, I'm telling you, if you learn, I've memorized it. I'm a former federal prosecutor, so I had to memorize the rules of evidence. But law school,
At Berry University in Orlando.
Okay.
St. Thomas Law, Your Honor.
Okay.
Nova Southeastern.
Okay.
Nova.
Nova Southeastern.
Oh man, these Nova people.
KP.
So you want to ask them any questions? Or you know now you know a little bit more about them.
I think you guys did a wonderful job. I think you all carried yourselves very well. You presented in front of us very well. I think you addressed the judge honorably and very well. From what I've seen in trial, it
They
was
scared
properly
me,
done.
and they don't know what's in my purse. That's why I said my bailiff for my purse.
I saw that in the middle of the trial.
Eugenie with me, I got your jello for you. Okay.
I think we have future Shaheen Hashemians here. I think if the panel presided of, not us, 6 plaintiff working people, my general opinion would be that I think the defense would have gotten that verdict. I think they presented information a little bit more clearly.
Their expert was better.
Their expert was better, I think.
What you pay for?
I think that's exactly right. I think us in the field understand that that's how that works. So we kind of see through it. But I think for the general consensus of what a human is outside in the world that would get called to a panel, I think it would have gone differently. But I congratulate you all. I think you did a wonderful job.
Yeah.
I think you could find your place here if Howard allows it. But seriously, good job. It was a pleasure to be here.
Yeah, you guys did really great.
Yeah, thank you.
You hear from everybody else? All right.
Bailiff, how did they do?
Yeah, I said the bailiff has to keep you safe, which is the most important.
I think he was a great bailiff.
Yeah.
I like his voice.
Right? I was like, you're very loud.
All right. Well, thank you, Judge.
Oh,
Really
my
appreciate you
pleasure,
coming.
my
You
pleasure.
always do such a
Thank
great job helping us and, showing your skills as a judge and keeping everybody on their toes, which is great.
It's a
Really
pleasure.
appreciate you, Judge.
It really is. I only come back, put my robe on for y'all. No.
I appreciate it. Here you go, a little thank you gift from us.
Oh.
And hopefully we'll get to see you. Love to see you year after year.
Well, this was a new problem, because years before we did the racetrack thing
Yep,
with
that was-
the jockey.
Uh-huh.
And so when I saw this, I think I got it Thursday of last week, and I opened it on Friday. I said, oh geez, I got to
Uh-oh,
read.
gave you work to do.
But it was worth reading, and I did. I read everything. They don't believe that I read it, but I read it. Y'all believe I read it?
I believe you read it, Your Honor.
You knew the case before we even began speaking.
Exactly
Okay.
right. Those are the good judges. You get judges that don't read a lot of things.
If you plead it, I read it. And I mean it. I promise that. But when I was invested in 1995, you all weren't born. But I stood on the stage at Bailey Hall at Broward, it was Broward Community College at that time. And I promised the citizens of Broward that if they pleaded, I'll read it. I did that for 24 years. I read everything.
Thank you for being our judge. Thank you.
And then finally, thank you to all of you for the hard work that you all put into this. I saw, as Richard said, you all talking to the walls, talking to each other, practicing in the courtroom here. It really shows the effort that you all put into it, so I really appreciate it. And everybody out watching, live streaming, I'm sure appreciates it too. So, no, you should really be proud of everything you've done. Great thing is it's all recorded, so you can watch yourself and critique yourself. I'm sure Rich will have some critiques for you tomorrow, but
In just a couple hours.
yeah. All in all, you did amazing. So I'd like to present to you a couple of awards for what you've done and your success. So Darlene, thank you very much and congratulations.
Thank you.
Briana.
Thank you so much.
So hopefully when you guys and girls get out and practice in the real world, you put in the same amount of time and effort into all your cases. Every time you go in front of a judge, it's important to be prepared. I can say I've been in a courtroom full of attorneys and I've seen some attorneys not so prepared. So make sure that when the judge is prepared and reads everything, you all gotta make sure you read everything and be prepared also, just like you did today. So thank you again for all of your hard work and all your time.
Thank
I look forward to it.
The courthouse, y'all are here to scuttlebutt. You'll know what judges read, and you'll know which judges haven't lifted a pleading in their life. They just, they have the staff attorney sitting around, but don't get used to that. Because one day they will come in and they will have read your pleading so be prepared always. Now, how did it feel to be outnumbered? I got, Mary, I got St. Thomas, and then all the Nova people. And I could tell there was a difference, because the Nova people got a little attitude. She stood up, Your Honor, hey, you go, oh, okay, Nova.
I'm so sorry, Your Honor.
But the St. Thomas people, Your Honor, what is your objection? Okay, y'all, they south of the border, but
Try to be
y'all
as respectful as possible, Your Honor.
I know, but Nova don't care about that. Y'all got Bob Diaz and Mickey Rourke still over there trying to, oh Jesus.
Bob Diaz is still.
Oh, Lord, tell him, he was my mentor, Judge. Go tell him it's time for him to go somewhere and sit down. Okay. I'll tell him that. Okay, they should go eat.
Yes, we should,
They're hungry.
definitely, reserve that.
But you all can ask me anything, but I'm not gonna stay and eat, cause, I have been on a strict diet regimen. Lee, I don't know if you've noticed.
Wow, look at that.
Great, Your Honor. 60 pounds down.
Congratulations.
Guys, go take a picture with the judge.
Can I bring this with us?
Oh, I
Yeah,
have to go
sure,
back.
absolutely.
Oh, and thanks for the legend, for the names. I was looking at that, I can't remember all these names.